from the African Commission, we continue to observe excessive use of force by police in the enforcement of COVID-19 related measures, which are usually imposed within the context of a state of emergency or disaster. This is not a new phenomenon. Rather, COVID-19 has amplified what the Commission has previously identified as a critical human rights challenge, namely how to ensure that the use of force is rights-based, including under states of emergency or disaster. A state of emergency or disaster does permit the limitation or suspension of certain fundamental rights. However, international law does not permit the limitation or suspension of the right to life and freedom from torture and ill treatment. This is critical from the perspective of ensuring we have a rights-based approach to the use of force under states of emergency or disaster. So first, the right to life, as interpreted by the Commission in its general comment number 3, includes an obligation on African states to ensure that the use of force does not result in the arbitrary deprivation of life by law enforcement officials. The use of force by police must comply not only with the principles of legality, proportionality, and necessity, but also to precaution, which operates to impose a duty on the state to plan law enforcement operations in a manner that minimises the use of force. Further, the Commission has also set out context-specific guidance to African states on a rights-based approach to the use of force during arrest and during gatherings. And as we've seen, these have been the contexts for the most visible manifestations of excessive use of force in the implementation of COVID-19 emergency measures. The death of protesters by security forces in Nigeria last month being a tragic example of the implications of a failure to take a rights-based approach. Secondly, in terms of torture, it's settled under international law that unnecessary, excessive, or otherwise arbitrary use of force by police is completely incompatible with the absolute prohibition of cruel, inhuman, or degrading treatment, and where that use of force is intentional, is always unlawful and may amount to torture. So with such a clear normative framework guiding the use of force in Africa, why do we continue to face the challenge of excessive use of force? And why is it so acutely amplified during states of emergency and disaster? During this COVID-19 period, there's been some issues that have been evident. Orders from political and police leadership about doing everything necessary or taking decisive action or having zero tolerance with regard to the enforcement of lockdown laws is problematic. Language is important. This type of language sends a message to police officers to do whatever's necessary for enforcing extraordinary laws. It does not impart a message of restraint. The planning for COVID-19 related police operations in African states have overwhelmingly emphasised strict enforcement over taking a public health response to the crisis, and the police are at the front line of this approach. The loss of life and the infliction of harm for failure to comply with what would otherwise be minor criminal offences, such as failing to obey a curfew or engaging in a gathering, is inexcusable. Meanwhile, the commensurate checks and balances, such as parliamentary, statutory, and civilian oversight, are limited or curbed under states of emergency. This, on multiple levels, promotes a culture of impunity for use of force. Police oversight in many African countries are already weakened and compromised, and extraordinary measures during states of emergency further constrain the work at the very time when effective and independent oversight is needed. Finally, police training on use of force in most countries is limited to physical instruction on the operation of firearms and other equipment, without consideration of the principles of necessity and proportionality or precaution. When tensions are heightened because of states of emergency and disaster, our police are simply not instructed nor equipped to respond with a rights-based use of force. Honourable Commissioners, Honourable Chair, where do we go from here? What additional action can the Commission take? I'm going to end my input with these two short requests of the Commission. First, Resolution 447 proposes the development of a normative framework to guide African states on their human rights obligations in the context of states of emergency. This should include specific consideration of the role of the police and the use of force in the enforcement of extraordinary regulatory provisions, to reiterate the need for proper planning of enforcement, and to ensure mechanisms of effective oversight. And second and finally, we call for the Commission to consider the development of a model training program for police to promote a rights-based approach to the use of force. The training should be both theoretical and situational and equip police officers with the skills to ensure use of force is proportionate, necessary, legal and non-discriminatory during ordinary times, as well as understanding the continuing limitations on these powers during states of emergency and disaster. I thank you.
Thank you very much for that input on the use of force, including in the context of crisis or state of emergency, such as the COVID-19 pandemic, highlighting the various gaps in particular that require attention, starting from the kind of direction that is given at the political level by political leaders, all the way to the approach to enforcement of regulations, which is more security oriented rather than public health or humanitarian oriented. The issues relating to training, issues relating to capacity have also been highlighted, all of which have been indicated, have specifically been noted in Resolution 449, where the Commission actually called for a reform of legislation, policy, guidelines, training, as well as, of course, issues of capacity deficit and relationship between law enforcement and security institutions and members of society. These are all issues that indeed need to be followed up very seriously. May I now request the next speaker, that is Principal Police Commissioner Babukar Shefu. If you are with us, Principal Police Commissioner Babukar. Yes, I see you there. You have the floor, please. You have 7 minutes. Merci beaucoup. Bienvenue.
Merci. Merci. Bonjour, Monsieur le Président de la Commission africaine des droits de l'homme et des peuples, honorable commissaire, distingués représentants, chers participants. C'est un réel honneur pour moi de prendre la parole au nom de la POLIDH, Plateforme africaine police et droits humains, pour vous présenter la thématique sur le respect des droits de l'homme par les agents chargés de l'application de la loi dans une situation d'urgence sanitaire du Niger. Alors, ce qu'il faut retenir, c'est qu'à titre de rappel, quand même, la maladie à COVID a été découverte en Chine en décembre 2019. Elle s'est propagée rapidement et le premier cas a été déclaré au Niger le 12 mars. S'en est suivi une batterie de mesures qui ont été prises par le gouvernement. Le président de la République lui-même, à travers un message à la nation en 17 mars, avait encouragé en tout cas les mesures qui ont été prises. Et puis, le 27 mars, à travers également un autre message à la nation, il a décrété l'état d'urgence sanitaire, avec des conséquences comme la fermeture des frontières aériennes et terrestres, l'instauration du l'isolement sanitaire de la ville de Niamey. Alors, dès lors, il s'est posé, en tout cas au service chargé de l'application de la loi, 3 impératifs à respecter: la question de la sécurité, la question de la santé et surtout la question du respect des droits de l'homme dans ce contexte-là. Alors, que faudrait-il faire? Ces services-là ont dû prendre des initiatives en fait en matière de protection des droits de l'homme pouvoir au moins donc faire concilier ces trois impératifs, comme je l'ai rappelé, l'impératif de sécurité, l'impératif de santé et l'impératif de respect des droits humains. Alors, pour cela, il y a eu l'intensification des contrôles au niveau interne des services chargés de l'application des lois et également l'intensification de la communication avec la population, d'abord au sein de ces services-là et également avec la population dans le cadre des missions de prévention de ces services chargés de l'application de la loi. On a également, en termes de mesures toujours policières, noté l'interdiction des arrestations ou de garde à vue vraiment pour des faits mineurs qui ne correspondent pas au crime et autres. Alors, toujours dans le sens d'initiative en matière de protection des droits de l'homme, nous pouvons noter quand même l'assouplissement et l'accélération des traitements des procédures pour des personnes qui ont été interpellées dans le cadre, n'est-ce pas, de la gestion de la COVID, qui ont violé peut-être les mesures qui ont été prises par le gouvernement. En plus de ça, on avait noté également quand même l'intensification de contrôle par l'inspection générale des services de sécurité qui suit régulièrement comment les agents de police et les autres donc services chargés de l'application de la loi exécutent sur le terrain les mesures de nature, n'est-ce pas, à faire respecter les mesures qui ont été prises par le gouvernement. Une autre quand même décision courageuse et plus importante qui a été prise dans ce cadre-là, c'est surtout la remise gracieuse des peines de 1540 détenus pour des raisons humanitaires et pour pouvoir désengorger les prisons. Alors, il faudrait noter également, toujours en termes de ces initiatives-là, pour les restrictions qui sont prévues comme des conséquences, n'est-ce pas, de l'état d'urgence sanitaire, de couvre-feu ou de l'isolement sanitaire de la ville de Niamey. Ces restrictions-là ne concernaient pas les évacuations sanitaires. Ces restrictions également ne concernent pas les transports des marchandises, les missions des forces de défense et de sécurité et surtout des services stratégiques qui peuvent avoir des répercussions sur le respect des droits de l'homme, tels que l'eau, l'électricité, les réseaux de communication. Donc, pratiquement, ces restrictions-là ne concernaient pas ces services-là. Alors, les services chargés de l'application de la loi par rapport à la gestion de cette crise sanitaire ont rencontré beaucoup de défis. Mais en termes de défis, il y a beaucoup de défis. Nous pouvons quand même rappeler un certain nombre de défis. D'abord, c'est la remise en cause de l'existence même de la maladie par une frange importante de la population et également l'incivisme des populations. Il y a également des défis qui sont liés à la méconnaissance de la légalité d'exception par les agents, les agents chargés de l'application de la loi eux-mêmes et par les populations. En autre défi, c'est des défis qui sont liés d'abord à la protection des personnes qui sont interpellées et surtout à la promiscuité donc des services, en fait, des locaux de garde à vue pour ces personnes. Donc, on a trouvé que là, c'est une véritable contradiction. Comment concilier ces préoccupations? Alors, nous avons quand même, face à tous ces défis, ces préoccupations, nous avons estimé qu'il est important de noter un certain nombre de recommandations. Alors, au titre de recommandations, nous avons estimé qu'il serait utile, en tout cas pour les gouvernements, de définir des politiques de crise et de communication de crise pour pouvoir bien informer le public, mais vraiment bien l'informer en temps réel comme il le faut. Et il est extrêmement important aussi de définir une politique efficace en matière de soutien et de protection des personnes vulnérables, surtout dans nos pays pauvres. Nous avons estimé toujours à titre de recommandation qu'il est important de renforcer les services chargés de l'application de la loi avec les moyens technologiques de surveillance pour leur permettre de soutenir les moyens humains et matériels qu'on a de façon à permettre, en tout cas, à ces services-là de respecter ou de faire respecter valablement les droits humains. Toujours en termes de recommandations, nous avons estimé qu'il est important également de renforcer les connaissances des agents chargés de l'application de la loi sur le respect des droits humains en situation de crise. Voilà donc ce que nous pouvons dire par rapport à l'expérience du Niger en cette matière. Merci, Monsieur le Président de la Commission africaine des droits de l'homme et des peuples. Je reste entièrement à votre disposition pour d'éventuelles questions. Je vous remercie.
Thank you very much, Principal Police Commissioner Chefu. for sharing with us the experience of Niger as it relates to use of force in the context of the COVID-19 pandemic. We will come back to questions later on during the discussion. But I think the point that you have made about the need for striking a balance between the right to health, the human rights standards that apply in emergency situations, and indeed that of upholding law and order, which is important. Thank you once again. Merci beaucoup. The next speaker is Mr. Gilbert Sebihogo, who is the Executive Director of Network of African National Human Rights Institutions, NANRI. Mr. Gilbert, you have 7 minutes. You are welcome.
Thank you, Honorable Chairperson of the African Commission on Human and People's Rights. Honorable Chairperson, Honorable Commissioners of the African Commission on Human and People's Rights, Honorable State Representative, Honorable NHRI's representatives, civil society organizations, I thank you for this opportunity accorded to me to speak on behalf of the Network of African National Human Rights Institutions on the role of NHRIs in promoting community education and awareness of the criminalization of petty offenses. Of course, you understand that the role of promotion cannot go alone if you want to really realize the implementation of the principles on the criminalization of petty offenses. Our work on this, of course, started way back in 2015, rather 13, when we implemented a project on prevention of torture. And later on in 2015, when NHRIs met in Yaoundé, they adopted a Yaoundé Declaration, which also was the occasion to adopt the 25th April as an Africa Retail Detention Day that NHRIs continue to commemorate in terms of assisting in reducing the overcrowding of prisons and other detention facilities. So the work of NHRIs actually is based on their mandate as provided by the Paris Principles, which are the normative framework that govern the establishment, operations, effectiveness, and also determine some functions in terms of promotion and protection of human rights, and which make them effective. It is in this regard that NANRI designed the initial 2-year project on the role of NHRIs in the criminalization of petty offenses, and I'd like to really express our gratitude to other regional campaign members, including APCOF, and of course to our funders, I mean the partners who provide financial support, including the Open Society Foundation. So the 2-year projects started in 2017 and involved 5 national human rights institutions, namely Cote d'Ivoire, Ghana, Kenya, Malawi, and South Africa. We are now into the second phase, which just started this year, but of course, it has been affected by the COVID pandemic, but NHRIs are still trying to do their work. So their mandates and functions to implement the project through the implementation, of course, of national action plans that they adopted during different national consultative meetings, where they include also other national stakeholders. So some of the work they did, of course, it's about sensitization and capacity building. During the in-country stakeholder meetings hosted by NHRIs of those countries, it was noted that there is low level of awareness regarding what constitutes petty offenses across different key stakeholders, and also what needs to be done about it. These NHRIs, of course, have been working towards building the capacity of those involved in the criminal justice system namely the judges, the magistrates, prosecutors, police officers, counties and regional officers, prison warders, among others, on the application, of course, of the African Commission principles on decriminalization of petty offenses and other international soft laws relating to this thematic area. So additionally, there was the need to sensitize members of the public, of course, which is the subject matter of our session, especially those who are most likely to be arrested for petty offenses, such as hawkers, the sex workers, vagabonds, and street families. This, of course, went to ensure that the public put pressure on the governments to decriminalize petty offenses. Sensitization, of course, capacity building must be done to increase the public awareness. Of course, this is normally done through, as I said, the Africa Pretrial Detention Day, where NHRIs meet with those different stakeholders to play their promotional work. They've been also advising the governments and advocate for review of the laws. You can see that is, of course, their key mandates. And NHRIs from Liberia, South Africa, Kenya have been, of course, interacting with the government, especially during this period of pandemic, to try to alleviate the plight of petty offenders who are in prison. They've been building partnership and linkages. Of course, this work cannot be done by NHRIs themselves. For it to be successful, they needed the collaboration of other partners, including civil society organizations with whom they've been working. For example, the Malawi Human Rights Commission, the Kenya, Uganda, South Africa, in each of the participating countries have been able to convene national consultations, forums, bring together the non-state actors, state actors, and other stakeholders working on criminal justice system. So through the National Action Plan, they've been also engaging with the court. Of course, you understand that during this period, of course, there is an issue of having judges available to, of course, deal with the issues pertaining to petty offenders. But of course, some of NHRIs have been assisting courts in doing this virtually. As I said, the promotion work cannot work alone. Of course, there are also other protection work, including monitoring and reporting. And we would like to really have NHRIs contribute on the reporting mechanism, and especially when it comes to discuss how states decriminalize petty offenses with regard to the implementation of the African Commission principles. We'd like to see NHRIs also including there in their alternative reports. Of course, there is litigation. Litigation, as I said, NHRIs work hand in hand with petty offenders, either to provide legal aid, as well as assisting them through the amicus curiae in the court. For your own information, NANRI has also filed an amicus curiae brief in support of the Pan-African Lawyers Union advisory opinion on the African Court on the extent to which certain bankruptcy laws comply with the African Charter on Human and People's Rights. So, just to conclude, and of course, request or propose a recommendation to the African Commission, it has been brought to our attention that only NHRIs which are effective and really independent could continue to do their work during this COVID pandemic situation, meaning that we need to work with the African Commission to get NHRIs strengthened, either through advocacy. Of course, we have started working with engaging the states through the Permanent Representative Committee, NADIS, trying to sensitize states to support NHRIs, either financially or also strengthening their independence through adequate legal framework. In applying for affiliate status, we'd like to ask the Commission to also consider the aspect of effectiveness. We have noticed that all the NHRIs which apply for affiliate status, they receive affiliate status without due consideration whether they are effective or if they need also other support from the government to make them really relevant to their people. Of course, they claim that they have affiliate status. It's very good for the African Commission to have them on the ground, to interact with them, but working toward their effectiveness would help all of us. I would like to thank you, Honorable Chairperson, members of the Commission, partners, for this opportunity, and I remain available to ask for any question for clarification and also engage with the African Commission. Thank you very much.
Thank you very much, Mr. Gilbert, for that presentation, highlighting the work of national human rights commissions and the key role that they play, both in terms of advocating for law reform towards the decriminalization of petty offenses, in terms of providing training and support for various institutions, from parliament to security institutions to the judiciary, and of course the question also of engaging in litigation processes in order to address the plight of quote-unquote petty offenders, I think, who are actually criminalized on account of their status rather than being really offenders as such. So there is no reason why somebody with homeless should be criminalized for being homeless. So that is a very important area of, indeed, issue that we need to continue working on. Finally, we have Ms. Lindia Kembabadi, who is from ACHPR Sierra Leone, who would provide us the final input, and then we'll proceed from there to have the interactions, the interactive session. You have the floor, please. You are most welcome.
Thank you, Solomon. Good morning, good afternoon, wherever you're listening in from. My name is Lydia Winnie Kembabazi. I'm the legal manager at ACHPR Sierra Leone. Thank you, commissioners, distinguished guests, panelists, attendees, all protocol observed. I will be talking about the relevance of these simplified version principles within the communities we work with. But before I do that shortly, I would like to just introduce my organization. ACHPR Sierra Leone is the only human rights organization providing holistic access to justice and post-prison support to women and girls who come into contact with the law in Sierra Leone. We provide access to justice, legal empowerment, psychosocial and welfare support, and post-detention support. As well as providing these short-term interventions, we also advocate for law reform, which is our focus today on petty offenses, that is focused on changing a system that disproportionately traps women and girls in poverty and brings them into contact with the law. In Sierra Leone, ACHPR, with the support of OSIWA, has been doing a lot of advocacy work regarding key petty offenses that we identified that are common in Sierra Leone, specifically loitering, which is a bit vague and open to abuse by law enforcement officials because its definition is just being in a place and not providing sufficient account of where you are at that point. And sufficient account, of course, is left to the discretion of whoever is arresting to determine what is sufficient account. But of course, we also have non-payment of debt, where the offense of fraudulent conversion and obtaining goods by false pretense are wrongly applied to civil debt matters and criminalizing the non-payment of debt without fraudulent intent for poor women petty traders. Then also the minor traffic offenses, which lack clear sentencing guidelines and leave them open to inconsistent and discriminatory application. ADVOCAID and CAL, Center for Accountability and Rule of Law, with support from ASEWA, we've been calling for reform of petty offenses and decriminalizing poverty in Sierra Leone, specifically seeking access to justice and respect for human rights, and challenging the use of petty offenses, which are used in a very discriminatory way to target the marginalized women, including marginalized people in our society, including sex workers, drivers of motorbikes, market women. Today, when I look at the simplified versions, they could not have come at a timely time, but also I know that they are relevant to Sierra Leone, specifically in the communities we work with, and we know that knowledge is power. There are many human rights and economic consequences of petty offenses, since they often target the poor, and therefore the simplified versions of these principles are timely in ensuring that there's a reduction in disproportionate effect of the poor and marginalized. If people are able to understand their rights, their laws, and the protection that is offered to them by certain laws, and bring their duty bearers to account, of course, then there will be a huge reduction in disproportionate effect of the poor and marginalized. These offenses, of course, disproportionately applied to the poor, who rely on maybe loans to sustain their businesses and being unable to pay fines. We tend to have advocacy meetings and sensitization sessions with the police and different stakeholders, who I believe now with this will be able to know the difference between applying criminal matters to civil debt related issues. I know that also the simplified versions will increase the protection of human rights and understanding of legal rights and cause legal empowerment, because now people will be able to use the law, to use it to claim their rights, to protect their rights, and especially loitering for people who are arrested for going about their daily activities, and know that this can amount to a violation of a person's liberty and freedom of movement, and also non-discrimination. I hope that the relevance of these simplified versions will, of course, reduce the emotional and financial impact we see on families, including children. Criminalization of these petty offenses, of course, can entrench poverty and burden families whose income depend on petty trading and informal businesses. We have had cases where a bike rider has been arrested and his bike confiscated just for parking in a wrong place or having a defective light signal. So I believe that once people are empowered to claim their rights, but also the duty bearers to know that they cannot do some things to some people because they are protected, I really believe that there shall be a reduction in emotional and financial impact on families, but also the overall cost to the justice and law order sector. An excessive number of petty offenses and charges place a huge...
Sorry? Mbabezi, is the Portuguese sound coming? Somebody is indicating that the Portuguese sound is not coming. Okay, all right, you can proceed, please.
Right, I was at the point where I'm saying they are relevant to reducing the cost to the justice and law order sector, because an excessive number of petty offenses and charges put a huge burden on the police, the courts and correctional centers, more so during this time where there's been so much measures put in place to curb the spread and prevent COVID-19, definitely there's been a huge strain on the justice, law and order sector. I believe that once these simplified versions are circulated, are put to the attention of all in play, in power, and in positions to reduce, decriminalize, and declassify some of these petty offenses, we know that the cost to the judiciary, to the justice, law and order sector will be minimized. Furthermore, in our times, perilous times of the pandemic COVID, I believe overcrowding of correctional centers, detention centers will definitely be reduced. Overcrowding, of course, leads to inadequate physical conditions, unable to protect individuals, one from COVID, there are no necessary safeguards, and also protect individuals from ill treatment. And finally, I know that there will be a mitigation on all the opportunities that people in power, the police, use as an opportunity for abuse and corruption. Since some of these laws are vague and open to their own interpretation and discretion, the law enforcement officers, of course, will definitely not be in position when people are empowered with their own understanding of laws and rights to be able to undermine the rule of law. And of course, this will go a long way in mitigating abuse of power and corruption. So as I conclude, I implore and join civil society across the continent as we work alongside the African Commission for Human and People's Rights to recognize that there's a huge need for reform of petty offenses that will enable our government to comply with obligations under the African Commission principles and other international, regional, and human rights standards in line with their respective constitutions. I call upon the decriminalization, declassification of petty offenses to contribute to a huge respect of rule of law. And I hope that the simplified versions that will be launched today will bring to light the lack of recognition of the negative impact of petty offenses. It will reduce excessive use of custody sentences for loitering, fraudulent conversion, and other petty offenses across the continent, but also go a long way to increase the awareness of public of their rights and legislation related to petty offenses in Sierra Leone and as Africa as a whole. I thank you.
Thank you. I think in the interest of time, I would rather like us to proceed to the interactive session. So if colleagues, members of the Commission and colleagues from delegates of states and HRIs and CESOs, if you wish to take the floor, I kindly invite you to do so. I wish to request the support of my colleagues in the Secretariat if there are delegates who wish to take the floor. I'm also checking on my colleagues, members of the Commission. I see Commissioner Amesbury. Commissioner Amesbury, please take the floor. Thank you.
I'd like to thank all members participating, all dignitaries and all participants. Good morning. I have a very short question in regards to petty offenses, the decriminalization of petty offenses.
Your mic is now off.
I do agree with the definition of petty offenses provided. However, I would like to ask whether in this day and age, whether the use of cannabis for personal use cannot be classified as a petty offense to be included in the list as defined. Thank you.
Thank you, Commissioner Amesbury. On that question relating to whether we can include cannabis or the personal use of cannabis as something that can also be included for decriminalization. Okay, any other input from colleagues, members of the Commission? I see. Okay, Commissioner Hattem. Yes, please. Commissioner Hattem.
Merci, Monsieur le Président. Bonjour à tous les collègues commissaires. Bonjour à tous les représentants des États, des ONG, des INDH et à tous mes amis du secrétariat et de la cabine. Je remercie ma collègue, la commissaire Maria-Thérèse Manuela, pour ce panel qui nous intéresse beaucoup au comité pour la prévention de la torture en Afrique. Parce que la question de la dépénalisation des délits mineurs nous soulage et amoindrit donc les risques de torture dans les prisons et dans les lieux de détention. Et le comité, depuis de nombreuses années, a appelé à cette dépénalisation. Pourquoi? Parce que vous savez que la surpopulation carcérale est un facteur qui rend le séjour dans ces détentions pénibles et qui facilite les mauvais traitements et les traitements dégradants. Donc, c'est très important et la commissaire Maria-Thérèse sait que nous travaillons toujours la main dans la main pour ces questions-là. Elle est d'ailleurs membre de ce comité. Et donc, la question de la commissaire, de l'honorable Amesbury, vient à propos parce que beaucoup de pays, dont le mien, donc, veulent traiter cette question-là de la dépénalisation de certains délits mineurs, comme la consommation de drogue douce ou bien certains délits, je dirais, mineurs d'ordre sexuel. Mais je n'ai pas vu le lien. D'abord, je remercie tous les panélistes. Chaque intervention était pertinente, mais je n'ai pas vu le lien entre le thème de la dépénalisation des délits mineurs et les exactions et les dépassements observés par les forces de l'ordre lors de la Covid. Donc, c'est ça ma question. Quel est le lien entre ces mauvais traitements et ces exactions lors de cette pandémie et la dépénalisation des délits mineurs? Donc, une fois encore, je remercie tous les intervenants de ce panel qui nous intéresse beaucoup, surtout en Afrique, pour soulager donc les prisons, la surpopulation. Et je voudrais également signaler un élément dernier, alors qui n'a pas été abordé. C'est lui qui a phénomène de surpopulation carcérale par les gens qui sont en détention préventive. Et parfois, ces périodes de détention préventive sont très longues. Et là, c'est un phénomène qu'il faudrait signaler aussi. Je vous remercie.
Thank you very much, Commissioner Hattem, for that. And indeed, for highlighting the close relationship and area of interest with your portfolio on the Committee Against Torture and this work by the Special Rapporteur on Policing and Conditions of Detention in Africa, Commissioner Manuela. I'm not sure if I have any other requests from the floor from, okay, I see Commissioner Amesbury requesting for the floor again. I will give Commissioner Amesbury the floor.
Thank you again, Chair, and all members. Again, if the aim of decriminalizing petty offenses is if one of the aims is to decongest prisons, and it's a noble aim. So, and before, at a time that a person is charged, but not yet convicted, all constitution or most constitutions say that the person is presumed innocent. In Seychelles, it says they are innocent. Therefore, if they are innocent or if they are presumed innocent, the question is, what is the justification for keeping innocent persons or presumed innocent person in pre-trial custody? Or whether it's time for us to move that pre-trial custody is also done away with if we want to decongest and if we want to promote human rights of people who are innocent. Innocent people do not belong in jail.
Thank you very much, Commissioner, once again, for highlighting the issue of pre-trial detention. I'm sure colleagues who are in the panel would address that. Just for delegates of states and NHRIs as well as CSOs, I wish to indicate that unlike the in-person session, this may not be the most convenient platform to have an active participation. I sincerely regret that. But if you have comments, questions for panels, kindly put your questions and comments on the chat platform. And also, if you communicate with colleagues in the Secretariat, if you wish to take the floor directly, that can also be arranged. I just wish to make this point to enhance participation of all delegates during our panel discussions. There is one comment, and then I'll come back to the panel. Somebody by the name Flavia Dalwango. This is a very good development in decriminalization of petty offenses. However, how is the Commission going to ensure dissemination of the document in various countries? How is the Commission going to ensure dissemination of the document in various countries? So this is a question about what the strategy of the Commission is for dissemination of this document. So let me come back to you, Commissioner Manuela, if you wish to take and respond to any of the comments and questions that have been raised. And we'll go to the other members of the panel. Thank you.
Obrigada, Sr. Presidente. Obrigada a todos quantos intervieram. Devo agradecer a Luísa, ao Comissário Boubacar, ao Sr. Gilberto, à Sra. Lídia, por esta partilha e esta interação contínua entre nós para permitir que
Sorry, Commissioner Manuela. Sincere apologies. Do we have interpretation for French? Okay. Interpreters, are you with us?
I think we are okay now, Commissioner. I think we should be fine. The interpreters are online.
Okay, please, let's have all the interpreters, both for the French as well as English, please. Apologies again, Commissioner. Please proceed.
Dizia que devo agradecer a Luísa da APCOF, ao Sr. Comissário Boubacar, ao Sr. Gilberto, a senhora Lídia por esta partilha, por esta caminhada que estamos a fazer para poder efetivamente disseminar e por África e por todos os lugares onde pudermos estes princípios que trarão uma grande mais-valia à legislação criminal em África e, consequentemente, se vai refletir na qualidade de vida dos prisioneiros em África. Dizia que poderia rapidamente, o senhor presidente já teria respondido à ilustre comissária Alexia sobre a utilização pessoal de cannabis, se pode ou não pode ser integrada nesta lista. Na versão dos princípios, não existe uma lista fechada de crimes menores que possam ser descriminalizados. Dá-se um exemplo geral daquilo que pode ser descriminalizado, porque muitas das legislações penais vigentes em África vêm do período colonial. E, na atualização, os países africanos vão verificar quais são aquelas infrações que devem, efetivamente, sair da lista de infrações para outras listas de prevenção, para listas, por exemplo, do direito administrativo, do direito civil, do direito comunitário. E o uso pessoal de cannabis, em muitos países, ele é tolerado, e sendo tolerado, pode perfeitamente ser descriminalizado. O uso pessoal, porque quanto ao tráfico em grande escala, isto já é um outro problema a ser tratado. Isto realmente haveria de ajudar bastante aos países a verificar, a rever a lista dos delitos que podem ser descriminalizados. Rapidamente responder ao meu irmão Hatem sobre a ligação entre a descriminalização de pequenos delitos e a ação policial em tempo de pandemia. Devo dizer que estamos a lançar 2 documentos. O primeiro documento é a descriminalização dos pequenos delitos e o segundo documento trata das questões relacionadas com a polícia e direitos humanos. Por essa razão, alguns dos nossos intervenientes falaram sobre a ação policial, porque são questões que vêm tratadas no boletim número 14. Como os 2 documentos são do mesmo mecanismo, então repartimos para que esses 2 temas pudessem ser tratados. A maior parte das questões relacionadas com a ação policial vem retratada no boletim número 14, que também vamos aproveitar e lançar neste momento. A senhora comissária Alexia torna a colocar a questão da detenção preventiva, se podem essas pessoas ser restituídas à liberdade para permitir descongestionamento das cadeias. Em princípio, se estão lá estão em liberdade, estão em prisão preventiva, por delitos que permitem que as pessoas aguardem em liberdade pelo julgamento, seria um bom exercício por parte dos Estados que essas pessoas nunca entrassem para as cadeias, que aguardassem a prossecução processual em liberdade, seriam chamados para julgamento e, ao invés de aplicar medidas detentivas, havíamos de encontrar outro tipo de medidas de penas para substituir as medidas de detenção. Se for por crimes graves, penso que a legislação de cada país dá resposta a isso, porque a maior parte diz que, a partir de um determinado número de anos de prisão para a condenação do crime, não pode aguardar em liberdade. Portanto, isto depende de cada Estado avaliar se deve ou não colocar na prisão por prática de algum determinado delito. Senhor Presidente, não sei se devemos continuar ou algum membro do painel também quer dar alguma chega às questões que foram colocadas.
Thank you, Commissioner Manuela. There were points at which we had difficulty connecting with you, but I think the points that you have raised particularly, I think, the distinction that you have introduced between the trade in cannabis and the personal use of cannabis, and the proposal that you have put forward for the Commission in that respect, in response to the question from Commissioner Amsbury, is very well noted. May I now give the floor to Ms. Edwards, if you wish to take the floor.
Thank you, Honourable Chair. I just wanted to quickly respond to the issue of the decriminalisation of cannabis. Like you, I had difficulty following the translation for Commissioner Manuela's input, so I sincerely hope that I'm not restating anything she has. But just to note that the focus of the principles is to decriminalise offences that target a person because of their status, or which criminalise life-sustaining activities in public spaces. And for that reason, the list was enunciated as it is, though it is not exhaustive. And there's certainly other ways to look at it. And if you look at the intent behind the principles, the intention is to decriminalise certain offences to stop the harm caused by the criminalisation. And we know from research that we criminalise the use of cannabis, the knock-on consequences actually include other forms of criminal conduct. And where we see a decriminalisation in countries, for example, like Portugal, we've seen a reduction in an associated crime rate. And just finally on that point, that the principles do provide a test to determine whether the criminalisation of an offence is reasonable, necessary and proportionate to the harm or the threat caused by the behaviour. And there's a lot of research to say that the criminalisation of cannabis is not appropriate, necessary or proportionate to the harm caused, and that criminalisation itself can exacerbate the harm. And then finally, just to welcome the call for the end of pre-trial detention. As the Commissioner will know, the principles on the conditions of arrest, police custody and pre-trial detention in Africa, which the Commission adopted in 2014, really tried to set out when it is appropriate to use pre-trial detention and when it is not. And it was clear that it should not be used in the context of minor offences. So I certainly support the call of the Commissioner to push that further, but also to do more work around linking the idea of petty offences with reform to pre-trial detention. Thank you very much, Chair.
Thank you for that. May I invite Commissioner Shefu for intervention? I saw you raised a hand to respond to observations made. Please.
Merci. Merci. Monsieur le Président de la Commission africaine des droits de l'homme et des peuples, honorable commissaire, je voudrais en fait réagir par rapport, même si déjà honorable Maria a donné des réponses par rapport au lien, à la préoccupation de l'honorable Hatem par rapport au lien qui existe entre la dépénalisation des délits mineurs et la gestion de l'ordre public ou la question du respect des droits de l'homme en situation d'urgence sanitaire. En fait, l'intérêt ici, je pense, c'est de démontrer quand même les répercussions que la situation d'état d'urgence. Lorsqu'on décrète l'état d'urgence sanitaire, la question du couvre-feu ou la question de l'isolement, la répercussion que ces décisions-là pourraient avoir sur les droits de l'homme, surtout sur les droits des plus vulnérables, les plus pauvres. Nous avons vu sur le terrain comment il était extrêmement difficile de mettre en œuvre, en fait, dans la pratique, les mesures qui ont été prises et qui tendent à protéger les populations contre la COVID-19 sur le terrain. Parce que si vous prenez la particularité des pays pauvres, vous allez voir ces mesures, le couvre-feu de 19 h, par exemple, à 6 h du matin. Cela suppose que la pauvre personne qui pourrait sortir, peut-être c'est à cette heure-là qu'elle pourrait sortir pour aller chercher du pain ou autre chose, elle est limitée. C'est des restrictions des libertés, des restrictions. Donc, je pense que de l'autre côté, la dépénalisation des délits mineurs vise aussi à avoir des répercussions sur les droits de l'homme. Donc, nous avons vu aussi d'un point de vue pratique comment est-ce que la justice a souhaité qu'on ne prenne plus des mesures de garde à vue ou qu'on n'arrête plus des gens pour des délits mineurs. Donc, cela veut dire qu'en réalité, en pratique, on pourrait le faire, on peut avancer. C'est vrai que c'est la situation de Covid qui l'a amené, mais cela veut dire qu'en réalité, même en temps normal, il y a des situations pour lesquelles on n'a pas besoin de garder les personnes pour certains délits mineurs. Je pense que c'est en cela qu'on pourrait voir aussi le lien qui existe quand même entre la dépénalisation, l'autre thématique et la seconde thématique. Je vous remercie.
Thank you very much. I am really pressed for time. So I wish to just make a quick request from Mr. Sebhego to make just a quick final point. Less than 1 minute, please.
Thank you, Chairperson, members of the Commission, delegates. I think the time allocated was rather insufficient, and we cannot explore all the issues around the decriminalization of petty offenses. Of course, including also the lack of data when you go to the prisons. You cannot really get accurate data because of the systems which are there and the digital system which is not effective. I think that for us all to be able to tackle this issue, we really need a multi-stakeholder approach. Strengthen the capacity of all the stakeholders involved in this campaign, including, of course, the state actors, the judiciary, the parliament, so that we can move together. Otherwise, the issue is really big, and we need to work together. And of course, assisting the African Commission on disseminating these principles, because that is our work. The African Commission cannot reach out to all the African citizens, but we are here, NHRIs, CSOs, NGOs, as the eyes and ears of the African Commission. So for that, I will thank you for this opportunity and remain available to support the dissemination and the implementation of the principles. Thank you, Chairperson.
Thank you. May I request Ms. Kambabezi also to make a concluding point in 1 minute as well? Thank you.
Thank you very much, Honorable Solomon, for today's sharing. As I conclude, I would like for us to say that there are very many ways we can call for reform of petty offenses and decriminalization of poverty in Africa as a whole. But I know that this takes not only us, but various stakeholders that we need to engage to ensure that all these laws do not act in a discriminatory way to target the marginalized people in our communities. So I implore everyone to bring everybody on table from the grassroots to the top end, so that when we are having a call for all these reforms, no one is left behind. Thank you very much.
Okay, thank you. With that, we now come to the occasion for jointly launching the, I think, the principles in their latest version or format. So if you wish to please show us, yes, I can see Mr. Sebhego and the panel members showing Commissioner Manuela. Yeah, excellent. I think we are happy that we have launched the simplified version of the principles on the decriminalization of petty offenses. Thank you very much for the work that has gone into developing this simplified version. And we look forward to the follow-up and implementation and indeed popularization of this document, as well as the main document So congratulations to Commissioner Manuela for the work that has been done. And we thank you all very much for your participation. That brings our panel to the end of today's session. I wish to again clap to all of you for this very rich conversation that we have had, highlighting quite a very important points and the new additional items or insights that have also been highlighted with respect to the personal use of cannabis. And of course, I think it bears to repeat that the purpose really is our societies need to be very conscious of human and people's rights as far as the application of criminal law is concerned, that people shouldn't be criminalized or their status shouldn't be criminalized, that poverty is not a crime. Poverty is a socioeconomic condition for which society itself should bear responsibility rather than criminalizing it, and should do everything to address poverty. That is why it is so important that we indeed campaign for and ensure the implementation of these principles across our societies. And for that, the work of this commission, partner organizations who attended this panel is so critical. And we do hope that states parties to the African Charter attending this session today will take away from this panel the important message that have been conveyed on the imperative for implementing these principles through legal reform, through public awareness of these conditions, and indeed through socioeconomic measures for lifting the conditions of people in these situations so that they have a dignified life as is deserved of any human being. Thank you all once again. I think we don't have that much time for us to commence the next item number 4 on the state of human rights in Africa. What I rather wish to indicate is for us to take a short health break and be back in 15 minutes so that we proceed with the next agenda item. In the meantime, I wish to request Etwell and colleagues in the interpretation booth to see to it that particularly when we have the Portuguese interpretation, I don't think that we should have these issues. We should have these issues again and again. So I really would like colleagues to make sure that they are always on standby for the Portuguese interpretation, but for all the interpretation work as well. We thank you so much for the interpretation work done. I think we can improve as we go forward. Thank you very much, and have a well-deserved short health break. Thank you.
J'ai fini le ca, le to, le mi.
Okay, colleagues, may we now commence and proceed to the next item, and this is the item on the human rights situation in Africa. I'm not really sure if there are any delegates of states parties who have registered and may wish to take the floor at this point in time for today's session. In the list, I don't have any. So what I will do is I will proceed to request colleagues in national human rights institutions if they are with us, and I will request them to take the floor. Let me start with CNDH Mali. Do we have Agwebu Boare? Do we have Agwebu Boare? It looks like that we do not have Agwebu Buhari. So let me ask, let me check if we have CNDH Mauritania. CNDH Mauritania. Atwell, do you see anyone online? It looks like we have somebody. Mr. Salem.
Muito bom. Muito bom dia a todos. Não sei se me...
Okay, who is this? Well, do we have the...
Yes, we have a person by the name of Salek. They are the ones who seem to have indicated for Mauritania.
Okay, please. That is from the NHRI, right? Or is it from the state party?
No, NHRI's state party, we have Angola. We can see Angola online.
Okay, then can we request... Okay, let's do this. I see indications that we have Angola are the state party to the African Charter who wish to take the floor. So may I ask then the Secretary of State for Human Rights of Angola to take the floor?
Anas Celeste. Move the promoter. Okay. Select person.
Do we have the Secretary of State for Human Rights of Angola? Okay, we have.
Já? Aonde? Ok. Ok. Muito obrigada. Penso que agora já me movem. Ok. Muito obrigada, Sr. Presidente.
You are most welcome. Yes, please.
Thank you. Muito obrigada, Sr. Presidente, Comissário Solomon Derson, honoráveis comissários, ilustres representantes das organizações da sociedade civil, Estados-membros, distintos convidados, minhas senhoras e meus senhores. É para nós uma honra participar em mais uma sessão desta comissão, num contexto ainda afetado pela pandemia da Covid-19. Lamentavelmente, a pandemia continua a ceifar muitas vidas humanas no mundo, em África e em Angola. Aproveitamos para partilhar com todos aqui presentes nesta sessão online. O Estado angolano continua a trabalhar arduamente para fazer face à pandemia, tendo tomado medidas proativas para a prevenção e controle da propagação da mesma em território nacional. Minhas senhoras e meus senhores, distintos convidados, após a OMS ter declarado o surgimento do SARS-CoV-2 como emergência de saúde pública global, o Executivo angolano mobilizou-se rapidamente, tendo criado a Comissão Multissetorial para a Prevenção e Combate à Covid, e elaborou um plano de contingência com orientações precisas sobre a resposta à pandemia, a fim de se planificar de modo eficiente a mobilização de recursos humanos, materiais e financeiros adequados. Os primeiros casos em Angola registraram-se a 31 de março, mas graças às medidas tomadas em tempo oportuno, a transmissão comunitária do vírus aconteceu somente 3 meses depois. Perante a crise, o Sistema Nacional de Saúde formou mais de 15.300 profissionais multidisciplinares de saúde para o tratamento dos casos da Covid-19. Criou 161 equipas de resposta rápida ao nível nacional e adquiriu 640 toneladas de material de biossegurança, equipamento de laboratório, testes, medicamentos diversos e ventiladores invasivos e não invasivos. Em termos de investimento, Angola saiu de 625 camas de hospitais e passou para mais de 5.000, 8 vezes mais do que as existiam. A nível dos cuidados intensivos, o número aumentou de 289 para 1.029 camas. A capacidade de testagem do vírus, o mecanismo vital para o controle da doença, passou de 90 testes diários para 13.000 testes entre RPCR e ELISA num sistema descentralizado. Ao mesmo tempo, foram construídos 4 centros de tratamento da Covid e hospitais de campanha. Em todas as províncias e municípios foram criadas áreas de isolamento em unidades sanitárias. Não sendo o novo coronavírus a única preocupação de saúde pública, urge prestar atenção a outras áreas com a saúde materna, neonatal e infantil, garantidas com humanidade, qualidade e eficiência. Um número considerável de unidades sanitárias foram reforçadas com gabinetes de apoio ao utente para maior humanização dos seus serviços. Nos últimos 3 anos, foram realizados grandes concursos públicos para ingresso e promoção de profissionais de saúde, que levaram a um aumento significativo da força de trabalho do Serviço Nacional de Saúde. De 70.525 profissionais em 2017, passou para 93.391 em 2020. As áreas perurbanas e rurais foram as mais beneficiadas. A taxa de médico por 10.000 habitantes passou de 1,2 em 2017 para 1,8 em 2020. Para aumentar o acesso aos serviços de saúde, foram construídas e apetrechadas unidades sanitárias em alguns municípios, fora das capitais provinciais, entre hospitais regionais, gerais, centros materno-infantis, hospitais municipais e centros de hemodiálise. Relativamente à saúde das crianças, foram realizadas campanhas de vacinação contra a poliomielite, tendo atingido uma cobertura de 85%. Esta ação, que teve início em 2019, permitiu reduzir os casos do pólio em Angola, de 124 casos para 2 casos registrados este ano. Um grande marco para Angola e para toda a África foi a certificação a 25 de agosto da erradicação da poliomielite selvagem em todo o continente. É de referir ainda que foi aprovada a Política Nacional de Medicina Tradicional e Complementar, integrada no Sistema Nacional de Saúde, com vista a garantir práticas seguras e sustentáveis de medicina tradicionais como incentivo à investigação. No quadro das ações tendentes a sensibilizar e educar os cidadãos sobre a pandemia do novo coronavírus, a comunicação social tem cumprido com a sua vocação e com a responsabilidade de informar a sociedade. Para o efeito, criou, entre outras ações, um serviço de informação diário com o número de casos, contaminações, óbitos, recuperados e ativos, e uma ampla divulgação das recomendações de biossegurança das autoridades sanitárias. Ressaltamos aqui que, nos termos do artigo 77 da Constituição da República de Angola, a saúde é gratuita e universal. Senhor Presidente, meus senhores e minhas senhoras, Angola, por força da pandemia, encontra numa situação de calamidade pública, situação que tem sido prorrogada em função do aumento do número de casos e a expansão da doença a todo o território nacional. Neste momento, contamos com mais de 13.000 casos. Nos últimos meses, registramos uma vaga de manifestações exigindo uma série de direitos. Infelizmente, nem todas as manifestações foram realizadas de forma pacífica ou observando os procedimentos legais. Foram abertos processos de averiguação e judiciais. O Presidente da República lamentou a detenção de jornalistas no exercício das suas funções e os espaços de diálogo estão a ser reforçados. A vida é um direito fundamental e, por isso, sempre deve ser salvaguardada e protegida. A garantia dos direitos das mulheres e das crianças continuam a ser as principais preocupações em matéria de direitos humanos em Angola. Neste primeiro semestre, em relação à mulher, houve mais de 4.000 casos e as crianças, o Serviço SOS Criança registrou mais de 33.000 casos, sendo que a fuga à paternidade, o abandono do menor e a exploração os principais. Do mesmo modo, ressaltamos a realização de projetos em parceria com organizações da sociedade civil. Gostaríamos de exemplificar os projetos de prevenção e combate à violência doméstica. O projeto Uma Palavra, um Abraço Virtual, projeto do parlatório virtual, que visa garantir via online acesso dos reclusos, assistência jurídica, advogados e contacto com as famílias. No dia 11 de novembro foi promulgado o novo Código Penal e o novo Código de Processo Penal, 12 importantes instrumentos de proteção dos direitos, liberdades e garantias fundamentais dos cidadãos. Outros diplomas igualmente importantes foram já aprovados, entre eles o novo Estatuto do Provedor de Justiça e o regime de organização e funcionamento da Provedoria de Justiça, a nossa Instituição Nacional de Direitos Humanos. O Estado assumiu o desafio de garantir também a todos os cidadãos nacionais o seu registro do nascimento e atribuição do BI. Neste sentido, foram criados e inaugurados, estão já a ser emitidos documentos em todas as representações diplomáticas e consulares dos países onde há um maior número de comunidade angolana residente. Senhor Presidente, honoráveis comissários e comissárias, meus senhores e minhas senhoras, relativamente ao tema do ano, desarmamento da população civil em países que viveram períodos longos de conflito e de guerra, como Angola, é uma prioridade. Nos últimos 12 anos, o Programa Nacional de Desarmamento da População recolheu mais de 111 mil armas de diversos calibres, sendo 80 mil entregues de forma voluntária e as restantes de forma coerciva. Este é um processo que decorre quase que diariamente. Antes de terminar, gostaria de agradecer o empenho pessoal do Sr. Presidente da Comissão, pois, durante a 66ª sessão, Angola finalmente recebeu as recomendações aos seus relatórios. Com isso, vamos elaborar o nosso próximo relatório do Estado sobre a Carta Africana dos Direitos Humanos e dos Povos e do seu protocolo relativo aos direitos da mulher em África. Entretanto, continuamos com as preocupações relativas à questão do uso do português nas sessões e documentos da Comissão. Senhor Presidente, honoráveis comissários, meus senhores, minhas senhoras, muito obrigada a todos e a todas.
Thank you very much, Madam. Very good to see you again. Angola participating in our ordinary session once again. And also thank you for your statement. I wish to start by welcoming the plan that you indicated for Angola to prepare the next state report under Article 62 of the African Charter and Article 26 of the Maputo Protocol. We look forward to receive Angola's report under these two human rights instruments, giving us a more extended opportunity for interaction with Angola. We look forward, we continue to push hard on our part at the Commission for ensuring that Portuguese is used and the necessary provisions for the use of Portuguese is availed. It hasn't been an easy one, more so because our push for getting that delivered hasn't yielded the expected fruit, but we will continue. And we would really appreciate the support of Angola, the state party indeed, for our commission in this quest for ensuring that we have a Portuguese interpretation and translation services available. We also welcome the update that you have given us in terms of the state of affairs since the 67th organization with respect to the COVID-19 pandemic and its impact in Angola. Indeed, it is it continues to be a major area of concern and preoccupation, not only because of the threat that it poses to health and life, perhaps more so because of the socioeconomic and humanitarian fallout of the pandemic and its impact on the economies of our countries, its impact on governance systems, and of course, importantly, on the lives and livelihoods of our people. We take note of course, the point around the demonstrations in Angola, where a group of people have been marching, demanding for improvement in living conditions, including particularly protesting against living expenses in Angola. And we received earlier in the week, you might have heard the statement from an NGO in Angola highlighting some of the consequences of excessive use of force from security forces, leading to the death of 30 people, according to that statement that we have received. Excellency, I wish to put to you that the African Commission wishes to request Angola to undertake an independent, transparent investigation into the death of the killing of people, 30 people that have been reported to us in the context of this protest movement, and indeed to take remedial action against perpetrators, but also to provide justice to those affected by the incidents. And we look forward to your feedback in this respect for the Commission. And of course, your feedback around the various cases that have been opened. As the African Commission, we welcome the regret that the President of Angola expressed about the arrest of journalists, and we look forward to this regret on the arrest of journalists being translated into action by releasing journalists who have been arrested for doing their job, for covering the protest events. We also, of course, agree with you fully that life must be safeguarded and everything must be done in order to secure both life and bodily integrity of members of society. Of course, while noting that protests need to be undertaken within the framework of the standards and principles of the African Commission relating to freedom of assembly that have been adopted by the Commission. We also express our regret indeed in this situation relating to violations affecting women and girls. And indeed, the number of cases, 40,000 cases having been reported in this respect is very alarming. And we encourage you, as a state party, to mobilize all sectors of society in order to address this scourge against women and children in Angola. And indeed, the 33,000 cases on children as well is very concerning as well. And wish to join you in supporting you towards addressing these issues. We also thank you for giving us update on new laws, including the penal code that have been promulgated. And we do hope that this code is in line with the African Charter and the principles and standards of the Charter as well as the Maputo Protocol. Thank you once again for your participation and for your statement. We look forward to your continued cooperation with our Commission. Next on the list is the representative of the Republic of Cote d'Ivoire, the state party representative. I wish to request if we can have confirmation as well, if we have the representative of Cote d'Ivoire, the state representative of Cote d'Ivoire. Somebody is saying, I think IT support is saying we have the representative for Cote d'Ivoire. In the list here, I have a name, Nyava Bongui. Nyava Bongui. Did you manage to see the representative of Côte d'Ivoire as well? Okay, good. I think we have the representative of Côte d'Ivoire joining us to make a statement of the Republic of Côte d'Ivoire. It looks like that we are having a bit of a problem with the connection, right, Etwell? I don't know. No, we have the connection. We have the connection. The vision or the video is not clear enough, but I think we have the representative of Côte d'Ivoire with us. Can you hear us?
On va le cumuler aux éléments du personnel géré par la zone. Je ne sais pas si vous voyez ce que je veux dire.
Mr. Bogui, can you hear us? Can you speak, please?
C'est ce que je vous explique. Maintenant, faites attention, vous allez voir.
We are not getting the audio, and the video is also a bit Mr. Bogui, are you with us? Okay, while we're trying to sort the technical issue for us to have Côte d'Ivoire to present a statement, may I go back to the other list from NHRIs? As soon as we have the technical issue sorted out, we will have Côte d'Ivoire to take the floor. Okay, do we have, I understand that there was an indication on the chat that Mr. Salem of the CNH Mauritania is with us. Okay, yes, I'm getting a confirmation from our secretariat that we have Mr. Salem with us. Mr. Salem of Mauritania. Mr. Salem of Mauritania. CNH Mauritania. Etwell, I'm not sure if we have. Okay. CNH Mauritania.
mayor presión asistencial en las últimas 24 horas en Murcia, aunque los contagios que empiezan a bajar en esta provincia.
Okay. Are you ready for us, Mr. Salem?
Yeah. Vous m'entendez? Allô?
Okay. Please proceed. Mr. Salem, please proceed. You are most welcome. Please proceed. Can you please tell him to proceed?
Allô? Oui, bonjour. Est-ce que vous m'entendez?
Yes, I can hear you now, yes.
C'est Monsieur
You are
Borbeli,
welcome. And
président de
please
la Commission
proceed.
nationale des droits de l'homme de Mauritanie. D'accord, je vous remercie. Je vous remercie de cette opportunité. C'est un plaisir de participer avec vous à cette session. La CNDH Mauritanie a travaillé ces derniers temps sur les sujets d'actualité, bien entendu le COVID-19, où nous avons créé un comité à notre initiative. On a créé un comité de vigilance avec le ministère de la Santé, le ministère de la Fonction publique et le patronat pour visiter les ministères, les administrations, les services publics, les entreprises et voir dans quelle mesure les conditions de précaution sanitaire sont respectées. Et comme vous le savez, nous faisons partie de ces États où le peuple ne prend pas beaucoup de précautions et prend les choses un peu à la légère. Donc, ce comité a travaillé et a été assez actif dans certains ministères. Également, nous avons entrepris des actions au sujet d'un certain nombre de questions qui sont prioritaires en Mauritanie, comme par exemple la violence contre les femmes et les enfants. La violence contre les femmes et les enfants qui fait l'objet d'un projet de loi qui est assez controversé, qui a été rejeté et amendé une ou deux fois et qui peine à sortir. Nous travaillons en étroite collaboration avec le Bureau du Haut-Commissariat des Nations Unies, le ministère des Affaires sociales, le Commissariat aux droits de l'homme pour faire passer ce texte dans la session qui est en cours actuellement. Et ce sera une grande avancée sur la lutte contre les violences contre les femmes et les filles. Nous travaillons beaucoup sur cette question. Également, nous avons entrepris des actions de formation, d'accompagnement, de suivi pour l'examen périodique universel avec la société civile. L'examen périodique universel de la Mauritanie sera le 19 janvier. Donc, nous sommes avec l'ONG UPR Info en contact. Nous avons fait de la formation avec la société civile, avec les diplomates. Et nous avons mis les diplomates en contact avec la société civile dans le cadre de la préparation de l'examen périodique universel de la Mauritanie qui aura lieu le 19 janvier. Également, nous avons une autre séance en vidéoconférence le 8 décembre, toujours dans le même cas. Nous avons adressé au gouvernement des avis consultatifs concernant le Covid et concernant la manière des restrictions de liberté pendant la période du Covid pour qu'elles soient nécessaires et c'est-à-dire ne pas dépasser le caractère du nécessaire et qui correspond à exactement ce qu'il faut en termes de violence et en termes d'arrestation, la proportionnalité nécessaire et proportionnelle. Nous avons adressé au gouvernement 2 avis consultatifs pendant cette période où il y avait pendant les couvre-feux des limitations de liberté. Nous avons travaillé ces dernières semaines sur l'ensemble des prisons du pays et l'ensemble des commissariats de police où nous avons véhiculé nous avons donné à ces policiers, à ces commissariats de police, des documents et des affiches contre l'esclavage, contre les mauvais traitements, contre la torture. Ça a touché pratiquement toutes les prisons de Mauritanie et tous les commissariats de police. Nous recevons les plaintes et nous sommes en train d'organiser un système performant en matière de plaintes qui est fait en collaboration avec la GIZ. Et nous sommes en train de faire des antennes régionales dans tous les pays, car les droits de l'homme, c'est pas dans la capitale, c'est pas dans une ville ou une autre, c'est dans tout l'espace du pays. Bien sûr, comme conclusion, nous avons travaillé sur les dossiers les plus sensibles chez nous, c'est-à-dire l'esclavage et l'état civil. En ce qui concerne l'esclavage, nous avons mis sur pied un comité avec le bureau du Haut-Commissariat des Nations Unies, avec certaines ONG crédibles pour traiter tous les cas d'esclavage annoncés. Car il y a beaucoup en matière d'esclavage, nous avons considéré au niveau de la Commission nationale des droits de l'homme qu'il y a deux ennemis principaux à la lutte contre l'esclavage en Mauritanie. Ceux qui, d'un côté, veulent fermer les yeux et ne pas traiter la question, et ceux qui, de l'autre, exagèrent et en font un fonds de commerce, et ni l'un ni l'autre ne servent la question, et ni l'un ni l'autre ne servent la Mauritanie. Donc, nous avons mis sur pied un système crédible avec le Bureau du Haut-Commissariat des Nations Unies, avec le FONAD, avec l'AMDH, et nous enquêtons sur chaque cas qui est annoncé par une ONG. Parce que jusqu'à présent, à chaque fois que les ONG déclarent dans une conférence de presse qu'ils ont identifié un cas d'esclavage et que des enquêtes sont menées par les autorités administratives, sécuritaires ou judiciaires, quand ils concluent que ce n'est pas un cas d'esclavage, les ONG reviennent à la charge dans une autre conférence de presse et considèrent que l'administration, les forces de sécurité, la justice sont complices, sont des esclavagistes eux-mêmes et ferment les yeux sur les cas d'esclavage. Donc nous avons adopté ce système. D'abord, personne ne peut douter de sa crédibilité parce que nous avons avec nous le Bureau du Haut-Commissariat des Nations Unies comme conseiller technique. Ensuite, ça permet de régler le problème. Donc, plus jamais les ONG ne peuvent dire que les États ont fermé les yeux parce qu'on sera témoin. Et plus jamais l'État ne pourra dire...
May I indicate to you that your 5 minutes is over?
Ah, d'accord. Donc, je conclus en disant que la Commission nationale des droits de l'homme essaye de travailler en étroite collaboration avec ses partenaires, notamment le Bureau du Haut-Commissariat des Nations Unies pour la promotion et la protection des droits de l'homme. Et nous sommes à l'écoute pour l'ensemble de vos recommandations et propositions. Je vous remercie.
Thank you very much, Mr. Salim, for the presentation of the National Human Rights Commission of Mauritania on the work that the Commission has undertaken, including in respect of COVID-19 by working closely with the Ministry of Health. The issue that you have highlighted, again, this is not unique to Mauritania, but clearly it is an issue that also concerns Mauritania, the issue of gender-based violence, which is a recurrent issue that we have been dealing with in many across the continent. Issues relating to, I think we welcome and we look forward to the state report of Mauritania, of course, and we commend the effort towards the preparation of the report. And we also commend your work, particularly the 2 consultative opinions that you have shared with government to ensure that government in taking measures relating to COVID-19 complies with human rights. And we would appreciate at the Commission, of course, if we get the contents and details of these consultative opinions. the issue of ill treatment of detainees by police, and the work that we are doing in that respect, as well as the prison visits. I think the issue of slavery that you have highlighted is a very important issue. I think it is a work that needs to be undertaken with a great deal of force and resolution, of course, not just in terms of the fact that it remains a taboo, as you have highlighted, in addressing public awareness, but importantly, I think the role of the police and security institutions and the judiciary in upholding the law and in enforcing the law. This is very critical in order to end this very inhuman, discriminatory situation that should be in the dustbins of history across the world. And we do hope that Mauritania succeeds in ending slavery in all its forms. And we look forward for a progress report in that respect. Thank you once again. May I now go back to the representative of Côte d'Ivoire? Can we try to have the representative of Côte d'Ivoire to the floor? You have 7 minutes, please.
Allô, vous nous entendez?
You are most welcome and you have 7 minutes.
Vous entendez la Côte d'Ivoire? Monsieur le Président,
we now can
m'entendez-vous?
hear you.
Monsieur le Président,
Yes, we can hear
m'entendez-vous?
you.
Je ne vous entends pas. Si vous m'entendez, faites-moi un signe.
Okay.
M'entendez-vous?
Yes, we can hear you. We can hear you.
Okay. Excellence, Monsieur le Président de la Commission africaine des droits de l'homme et des peuples, honorable commissaire, représentant des États membres, de la Commission de l'Union africaine, des missions diplomatiques et institutions partenaires de la Commission africaine des droits de l'homme et des peuples, mesdames et messieurs, c'est un grand honneur et un immense privilège pour moi de prendre la parole au nom de la République de Côte d'Ivoire et de son gouvernement à cette tribune de la 67e session ordinaire de la Commission africaine des droits de l'homme et des peuples. Permettez-moi de souligner à l'entame de mon propos que la Côte d'Ivoire s'honore une fois encore de participer à cet important forum continental des droits de l'homme que la pandémie du Covid-19 nous oblige à tenir en événement virtuel. Mesdames et messieurs, fortement attaché au principe de l'état de droit, mon pays poursuit inlassablement ses efforts pour la promotion et la protection des droits de l'homme. À cet effet, à l'effet de permettre à l'ensemble des populations d'en jouir effectivement. Ainsi, pour nous limiter à la période postérieure à la 65e session du mois d'octobre 2019, la Côte d'Ivoire a posé un certain nombre d'actes majeurs. Dans le souci de se conformer à ses engagements internationaux en matière de droits de l'homme, les rapports dus à la Commission africaine des droits de l'homme et des peuples et au Comité contre la torture sont en cours d'élaboration et seront soumis aux dits mécanismes aux toutes prochaines sessions. Pour capitaliser l'expérience acquise et à la recherche de bonnes pratiques, la Côte d'Ivoire poursuit sa coopération avec les organisations internationales, notamment le système des Nations Unies, le système des Nations Unies. Cela lui a valu d'être élu pour la 3e fois au Conseil des droits de l'homme le 13 octobre 2020 à 182 voix contre 6. Au plan interne, la Côte d'Ivoire poursuit ses efforts pour l'amélioration des conditions de vie de ses citoyens et partant pour plus de jouissance et partant pour plus de jouissance des droits humains. Elle a ainsi procédé à l'adoption et à la promulgation de plusieurs textes. Il s'agit, pour ne citer que celle-là, de la loi sur le nom, adoptée en mai 2020, à la suite des nouvelles lois sur le mariage, la filiation, la minorité, la succession, pour poursuivre la mise en œuvre du principe de l'égalité entre l'homme et la femme. Cette loi remplace le vocable de nom patronymique qui faisait la part belle au père au nom, supprimant ainsi la prééminence du père. Il s'agit également de la loi portant sur la représentation de la femme dans les assemblées élues, qui impose pour les scrutins uninominaux et de liste un quota minimal de 30% de femmes sur le nombre de candidats présentés. Cette loi prévoit également un financement public supplémentaire à tout parti ou groupement politique dont la liste des candidats atteint au minimum 50%. Mesdames et messieurs, le programme social de gouvernement dénommé PS-Gouv, d'un montant de 727,5 milliards pour 2019 et 2020, est entré dans sa phase active. En effet, prévu pour procurer du bien-être aux populations, plusieurs actions et activités de ces 5 axes stratégiques sont en cours d'exécution. À ce titre, à titre illustratif, je voudrais citer quelques-unes. Il s'agit de la construction et de la réhabilitation de plusieurs centres de santé de proximité, de la construction et de l'ouverture de plusieurs établissements d'enseignement scolaire et universitaire, de la réalisation d'infrastructures et de services essentiels tels que les routes, l'eau potable et l'électricité, de la mise en œuvre des guichets emploi jeunes, de la couverture maladie universelle. La Côte d'Ivoire, confrontée à la pandémie du coronavirus, a adopté plusieurs mesures visant à préserver et à protéger les droits des populations. Au plan sanitaire, l'État de Côte d'Ivoire a adopté une série de dispositions pour la sensibilisation de la population au respect des mesures barrières et pour freiner la propagation du virus. La prise en charge est gratuite. L'amélioration des plateaux techniques des laboratoires d'analyse technique, d'analyse médicale pour faciliter le dépistage est acquise. L'isolement des malades est également acquise. Toutes ces mesures ont été prises pour garantir le droit à la santé des populations. Au plan économique, d'importantes mesures d'importants moyens ont été dégagés pour soutenir les entreprises ainsi que les populations les plus vulnérables. Mesdames et messieurs, à la suite d'un processus de dialogue inclusif de plus de 6 mois, la loi portant recomposition de la Commission électorale indépendante a été adoptée et promulguée. Au mois de mars 2020, cette recomposition a été parachevée par ordonnance. En dépit de quelques difficultés, dues au mot d'ordre de certains partis politiques appelant au boycott actif, l'élection présidentielle du 31 octobre a été tenue sur toute l'étendue du territoire national. Les incidents constatés n'ont pas été de nature à entacher la crédibilité du scrutin. En tout état de cause, un dialogue vient d'être ouvert pour juguler les suites de cette élection. Pour clore mon propos, je voudrais, au nom de M. le Président de la République, Alassane Ouattara, féliciter et encourager les honorables membres de cet illustre mécanisme qu'est la Commission africaine des droits de l'homme et des peuples pour les efforts inlassables déployés sur le continent, efforts dont les effets sont aujourd'hui perceptibles sur le continent. Je vous remercie pour votre aimable attention.
Thank you very much, distinguished representative of Cote d'Ivoire, also for delivering the statement within the time allocated of 7 minutes, and for the update that you have provided us in terms of measures that have been taken by Cote d'Ivoire towards improving the state of human rights in Cote d'Ivoire. And we look forward to receiving the state report of Cote d'Ivoire, which you said is under preparation and expected to be presented during the next session of the Commission. We very much welcome that. It will give us a very good opportunity to engage in an in-depth interaction on the state of human rights in Cote d'Ivoire. The reference that have been made to the new law on marriage, minority and succession is also welcomed, particularly the measures taken for ensuring gender equality, as you have highlighted through the law, including in terms of assignment of names and by women. We also welcome the 30% requirement for candidacy of women. We take note of also, and indeed this is important, the various socioeconomic programs that you have made reference to in order to deal with socioeconomic issues and also fulfill socioeconomic rights in Cote d'Ivoire. I think the Commission has been seized with the situation in Cote d'Ivoire as it relates to the electoral process. And indeed, in that respect, it has pronounced itself. And we do hope that those pronouncements of the Commission are followed up, particularly in terms of the Commission, of course, encouraging the need and imperative for respecting for human and people's rights in all conditions. And we, in this respect, of course, regret the incidents that you have made reference to, including those that actually claimed, according to reports, some 80 people. And these are very serious issues in respect of which we request Cote d'Ivoire to undertake a thorough, transparent and independent investigations into the incidents that led to the loss of these large number of lives, and provide the necessary redress for victims and indeed accountability measures for perpetrators of these violations. And we also encourage Cote d'Ivoire to take steps towards enhancing national cohesion. And in this respect, we welcome the dialogue that have been initiated between the government and the opposition, since this may have very serious consequences for peace and stability in Cote d'Ivoire. I don't think that we have any other state party at this point in time requesting for the floor. So I go back to the list of national human rights institutions again. And here on the list, the next one is National Human Rights Commission of Nigeria. As well, can you check if we have a representative of the National Human Rights Commission of Nigeria? We have a name listed here, Anthony Ojuko. All right, no, okay. So we proceed then, the Ethiopia Human Rights Commission. The Ethiopia Human Rights Commission, I have been informed that Mr. Daniel Bakela have assigned a representative of the Commission to make a statement. Do we have Rakib Masala? Do we have Rakib Masala? Earlier, I have received a confirmation that Ms. Rakib Masala is with us. Okay, the Secretariat is confirming again that
hello, can you hear me?
We are being connected with Ms. Rakib. If Ms. Rakib can put on excellent.
Hello.
Good, excellent. Okay, very good to have you. Welcome to the session of the Commission. You have 5 minutes, please, and we look forward to receive your statement. Thank you very much.
Thank you very much, Honorable Solomon Ayala, and Honorable Commissioner Mudford Mudwenga, Country Rapporteur for Human Rights Situation in Ethiopia. Honorable Commissioner, ladies and gentlemen, my name is Rakib Masala. I'm very pleased to make this statement on behalf of Chief Commissioner Daniel Bakala. Honorable Chairperson, please allow me first to start with the reform process at the Ethiopian Human Rights Commission. As you're aware, in line with the political and democratic reforms in the country, the Parliament has appointed a new Chief Commissioner to lead the Human Rights Commission and initiate reform. And as part of the reform, the Commission has been identifying strategic priorities to work in collaboration with international and regional human rights mechanisms, such as the African Commission on Human and People's Rights. And in August 2020, the establishment proclamation of the Commission has been revised so that it becomes more independent and have the capacity to fulfill its mandate in accordance with the UN Paris principles. Let me now proceed to provide an overview of the human rights situation in Ethiopia. As you all know, there are a number of positive developments following the leadership change in 2018. For instance, in terms of civic and political space, thousands of political prisoners have been released, and notorious prisons like the Makalawi prison and jail Ogaden have been closed. And several officials and security officers have been prosecuted for their acts of torture and ill treatment. Exiled political groups and their members who have been previously labeled as terrorists have returned to Ethiopia and have started to participate in the political and democratic process of the country. In terms of legislative review, there's an advisory council that has been established by the Office of the Attorney General to advise on the review and reform of repressive laws. And some of the amended laws include the Anti-Terrorism Proclamation and Civil Society Proclamation. And the review of the Criminal Procedure Code has also been expedited, and the third National Human Rights Action Plan is being developed, and the Ethiopian Human Rights Commission is participating in the process. Honorable Chairperson, while the above mentioned positive developments are very welcome, we are also very concerned with the extremely concerning development. Most concerning is the sharp rise of incommunal and interethnic violence, resulting in scores of senseless deaths, bodily injuries, destruction of property, and large-scale displacement of people. And just the most recent attack was this Saturday in Benishangul Gumuz, that violent conflicts and intercommunal violence are unfolding in Oromia, Afar, and Somali regions along ethnic and religious lines against the backdrop of polarized politics, weak institutions, and fragile economy. However, it should be noted that the federal government has repeatedly deployed federal forces to restore and maintain peace and security. However, elements of the security forces themselves have been implicated in some of this ethnic violence. In terms of strengthening institutions, despite encouraging steps to reform and strengthen democratic institutions, weak law enforcement capacity, particularly in administration of criminal justice, remains a challenge. In terms of the COVID-19 restrictions, particularly the closure of schools, has meant children have not been going to schools and thus accessing education, and there has been increase in domestic violence and also violence against children and women. With regard to condition of detention and policies, while presence of high-profile detainees meets the minimum standards, most stations, police stations and detention in the region face serious limitations, and there have been some reports of police brutality and disproportionate use of force by law enforcement. So, while Ethiopia is preparing for election in 2021, some prominent political leaders have been arrested recently and charged with alleged offense of exciting inter-ethnic violence and preparation for terrorist attacks. And as you might well know, since November 4th, the country is in a state of war following months of tension between the Tigray regional state and the federal government. Communication has been severed in Tigray region, and even the commission has not been able to receive satisfactory information about civilian casualties for the humanitarian needs in the region. Honorable Chairperson, so the Ethiopian Human Rights Commission has highlighted the key areas in which concerted efforts must be made to ensure that human rights are protected in Ethiopia. And we call upon the Ethiopian government, the African Commission on Human and People's Rights, and other stakeholders to work with us to ensure that appropriate conflict analysis is conducted and dialogue facilitated between the concerned parties to find a sustainable solution, that the rights of women and children are ensured, especially addressing domestic abuse, that the condition of detention are improved, and that law enforcement officials, especially the police, continue receiving training on human rights standards and obtain necessary equipment to handle riots. And finally, that human rights are upheld and protected in the ongoing conflict in the Tigray region, including ensuring that communication is restored and humanitarian access and support is facilitated. I thank you all for your kind attention. Thank you.
Thank you very much, Ms. Rakib, for that statement of the Ethiopian Human Rights Commission. I'm very pleased to see the Ethiopian Human Rights Commission participating in this session. I have been in this commission for 5 years now. Perhaps I think this is the first time that I see the Ethiopian Human Rights Commission making a statement. So I really commend the commission for doing this. I also wish to welcome at the African Commission the various measures that have been taken by the Ethiopian Human Rights Commission to improve the working arrangement of the Commission by having the law on the Commission updated and also with the election of the new chief commissioner of the Commission as well. We very much welcome these developments. I have indicated in my opening remark that one of the commissions that in the course of this intersession period, whose work we have seen for commendation is the Ethiopian Human Rights Commission, and we really would like to see the Commission sustaining its very proactive and also effective discharge of its responsibilities in responding to the various human rights issues arriving in the current conditions in the country. The Commission on a number of occasions and indeed throughout the previous years have welcomed the various positive developments that you have made reference to in your statement relating to the political liberalization and the release of political prisoners, the invitation back to the country of political actors who have previously not been able to be present in the country, and indeed some of the other measures such as the closure of Maakalawi as well. And we join you at the African Commission in expressing concern, and indeed we have through the country rapporteur issued various statements expressing these concerns relating to various incidents of major violence violence that have been witnessed during the course of this period. I wish indeed to express condolences of the Commission to the families who have lost lives, who have been displaced, and who have been raped and attacked in the course of these violent incidents, including most recently in Benshangul Gumuz region that you have made reference to. And we do hope that everything is done to ensure that security forces indeed protect vulnerable groups from such kinds of attacks, that the conditions that lead to these violations are addressed, and that indeed investigations are, as you have indicated, undertaken in order to hold perpetrators of these violations accountable, and victims are provided with the necessary support and legal redress that they deserve. We also take note of, I think this is a concerning trend across the various statements that we have received relating to the increase in domestic violence, spike in gender-based violence, as well as violence against children, which is a very concerning trend. And we do hope that conditions are also created for members of society, civil society organizations in particular, for women groups and those who cater for the rights and interests of children, in order for them to support efforts towards addressing the scourge of violence against women and children. We join you indeed in expressing grave concern about the state of war, as you have indicated, currently affecting the Tigray region. And we also welcome your call for communication lines to be restored, among others, so that you, at the National Human Rights Commission of Ethiopia, is able to verify and monitor the situation to ensure compliance with human rights and international humanitarian law. And indeed, we join you in calling that human rights and humanitarian law are duly respected, even in conditions of this state of war you made reference to. And we also reiterate your call for all actors to engage in a dialogue to resolve the ongoing situation, and indeed also for efforts to be undertaken towards addressing the conditions of women and children who are affected by violence, and indeed those of in conditions of detention, and the issue of excessive use of force and brutality of security institutions that you made reference to. Thank you once again for your statement. And I encourage the National Human Rights Commission of Ethiopia to continue its collaboration with the African Commission, and indeed to work closely with the country rapporteur. Thank you once again for that. The next is, I think, let me check. It looks like that we have the National Human Rights Commission of Kenya with us, because I'm trying to follow the list, but I'm not sure if colleagues, representatives of NHRIs on the list are with us today. So I will simply proceed to recognize the one that have been who is available with us, and this is the National Human Rights Commission of Kenya. Etwell, can you confirm if we have the representative of the National Human Rights Commission of Kenya, Dr. Elizabeth Kamundia?
Thank you, Honorable Chairperson.
You are welcome. You have 5 minutes, please. Thank you.
Thank you. Honorable members of the Commission, representatives from states parties, national human rights institutions, civil society organizations, and all distinguished guests, I bring you greetings from the Kenya National Commission on Human Rights. My name is Dr. Elizabeth Kamundia, and I'm pleased to make this statement on behalf of the Commission Secretary, Dr. Bernard Mogesa. I commend you for the important work that you are undertaking, and I wish to thank you for the opportunity to take the floor on this 67th Ordinary Session. I wish to read the Kenya National Commission's on Human Rights statement that highlights the impact of COVID-19 pandemic on human rights in Kenya based on the Commission's monitoring, advisory, and investigations and redress functions that culminated to our first situational report launched in June of this year entitled Pain and Pandemic, Unmasking the State of Human Rights in Kenya in the Containment of the COVID-19 Pandemic. And now on to the specific issues. The first one is in relation to the right to life, which has been violated, particularly during enforcement of COVID-19 prevention and control measures by law enforcement agencies. Between March and May of 2020, the Commission received 10 cases of deaths reported, 5 of which resulted from excessive use of force, assault and torture by police during enforcement of COVID-19 prevention and control measures. The Commission continues to receive complaints relating to the enforcement of measures under COVID-19, and to date has received over 300 complaints of this nature. The second issue is in relation to demand for access to justice, which has increased owing to more people being arrested or detained for violating the COVID-19 containment rules. On a positive note, the judiciary has leveraged on technology in court operations, and through teleconference, courts, prisoners, prosecutors, and advocates have been connected. And as at 17th April of 2020, 44 court sessions in 23 court stations had been facilitated via Skype or Zoom. These means have, however, been criticized for not being accessible to groups such as persons with disabilities, the poor in informal settlements, and those in marginalized remote areas. The third issue is on the right to education, which has been one of the most adversely affected. Following the first confirmed case of COVID-19 in March, the government announced closure of all learning institutions. And while the Ministry of Education has made use of alternative platforms, radio and television and YouTube, accessibility to these platforms has been unequal for students from poor households, marginalized, and persons with visual and hearing and intellectual disabilities. In relation to the right to health, the main concerns have been on access to essential healthcare services, including reproductive, maternal, newborn, and child healthcare, availability and adequacy of quarantine and isolation centers, stigma and profiling of COVID-19 victims and their families, sexual and gender-based violence, and compromised mental health of many individuals during this period. With regard to persons deprived of liberty, the Commission in its assessment established that the Kenya Prison Service, together with county governments, have instituted positive measures to protect the right to health of persons deprived of liberty. In relation to persons with disabilities, timely and accurate information on COVID-19 has been availed to the public in format also accessible to persons with hearing disabilities. However, access to information has not quite been extended to those with disabilities such as intellectual disabilities, and as a result, some of them have unknowingly flaunted directives in this regard. I'll move on now to the Commission's interventions. As an effective strategy for securing redress for violations occasioned by COVID-19, the Kenya National Commission on Human Rights has been involved in 3 court cases, one challenging the curfew, a case challenging the public health regulations on containment and restriction of movement, and thirdly, on the state of the quarantine centers. Secondly, the Commission has developed a monitoring framework to aid in monitoring the human rights situation in relation to the government responses to COVID-19. And thirdly, on advisories, the Commission has focused on monitoring proposed amendment and new legislation and has to date issued 8 advisories to various state organs to ensure compliance with human rights standards. In terms of recommendations, the Commission on Human Rights recommends that the state should ensure that a human rights-based approach is at the center of every regulation and measure adopted to protect the public during this pandemic, and that the measures taken must be necessary, legitimate, and proportionate to protect public health. The state must also not only respect the right to life, but also fulfill its positive obligation to protect life by conducting investigations into the excessive use of force by police, holding them accountable, and providing redress for victims of police brutality during the pandemic. In order to promote equal access to education for all students during the pandemic, the state should adopt special measures that factor in the unique circumstances of students from poor households, remote and marginalized communities, and students with different types of disabilities. And finally, the state must adopt special and targeted measures to mitigate the impact of the pandemic on vulnerable groups such as persons with disabilities, older persons, children, women, and groups and communities that are subjected to structural discrimination and disadvantage. We remain committed to support the African Commission on Human and People's Rights and look forward to continue engaging with the Kenyan state with this mechanism towards the promotion and protection of human rights. I thank you.
Thank you very much for that statement of the Kenya National Human Rights Commission. I am very pleased to continue to engage with the Kenya National Human Rights Commission as the country rapporteur and to get very good collaboration from your side. And I look forward to continuing engaging with you. I wish to bring to your attention, of course, in relation to the many issues that you have highlighted in your statement, the resolution of the Commission, Resolution 449, which was adopted during the 66th ordinary session, which addresses many of the issues that you have identified, particularly those relating to the right to health in various in its various dimensions, those relating to law enforcement and the enforcement of the COVID-19 regulation measures, and indeed the role that law enforcement and security institutions have to play in strict compliance with human rights. And we only reiterate and echo your call for a human rights-based approach to addressing the COVID-19 pandemic. And this, of course, is exactly the point of Resolution 449. And we do hope that you make use of and make reference to Resolution 449 also in your advocacy for this human rights-based approach in responding to COVID-19, including in respect of what you said, a targeted measure that needs to be taken to mitigate the impact of COVID-19, including the socioeconomic impact of COVID-19 on the most vulnerable sections of society, which is also a point that is underscored in our resolution as well. And we commend the work of the Commission in terms of the 3 court cases that it has initiated, the monitoring work that it has undertaken, and indeed the 8 advisories that it has issued in the context of the monitoring of the situation of human rights in Kenya as far as human rights issues arising in the context of the pandemic, including the more than 300 complaints that you said you have received. And I think on all these areas, the Commission is with you and very much welcomes your work and engagement, and looks forward to continuing collaboration with you and to support the Commission, your Commission, in discharging its mandate and responsibilities in all these areas. Thank you for that statement once again. The issue relating to, of course, the digital divide and its impact as some of the institutions such as the judiciary move to the digital platform, and indeed in the conduct of education as well, is a very serious concern. It is an area in respect of which access to internet is so critical and so essential, for which I'm sure you join our commission in campaigning for a universal access to internet in Kenya as well. I'm not sure if we have any of the other institutions from NHRI, so I will proceed to call on colleagues from civil society organizations, NGOs with observer status. I would like to request if we have with us Legal and Human Rights Center, Legal and Human Rights Center with observer status 244. The name of the speaker that would represent Legal and Human Rights Center is Raymond Paul Kenenye. Okay, I have indication from our secretariat that we have the representative of Legal and Human Rights Center. Okay.
Hello, can you hear me?
Okay, thank you for joining us. Can you put on your video? Okay, you are welcome. Kindly note that you have 5 minutes.
Thank you so much. Your Excellence, Honorable Chairperson of the Commission, State Delegates, Diplomatic Corps, dear participants. Legal and Human Rights Center would like to share the human rights situation in Tanzania during this 67th ordinary session. Our observation is divided into 4 parts, which are civil and political rights, economic, social, and cultural rights, protection of women and children, and protection of human rights in the business sector. To start with civil and political rights, Tanzania has experienced the enactment, amendment, and implementation of laws which, in our opinion, hinder enjoyment of fundamental freedom, such as freedom of expression and the freedom of association, as well as right to equality before the law, but also limitation in access to justice. For instance, the amendment of the Basic Rights and Enforcement of Duties Act, which restrict or narrow down access to justice by way of public interest litigation. Actually, the amendments are worrisome as they bar bona fide individuals, civil society organizations, and lawyers who are not necessarily affected directly by a particular violation of fundamental constitutional right from bringing public interest cases, seeking a group remedy, legal, social, or systematic change through courts of law. Honorable Chairperson, also the decision of the Tanzania to withdraw the rights of individual and NGOs to directly file cases against it at the African Court on Human and People's Rights. This has implicated in accessing to justice through regional courts. But also we have the constitutional challenge on the independence of the National Electoral Commission, which It raises continuous claims and allegations over the credibility of elections, conduct, and the results. Number two, economic, social, and cultural rights. Honorable Chairperson, Legal and Human Rights Center acknowledges the positive measures taken by the government to ensure progressive realization, such as fee-free education, which has significantly increased number of student enrollment in primary education. However, there are still constraints of inadequate funds, delayed and partial disbursement of the funds on education sector. Furthermore, there are still a challenge of the expulsion of pregnant schoolgirls, which limits girls' access to education and right to development. Number three, on protection of women and children. LHRC acknowledged the strength in the system in the protection of women and children in the country. However, there are key concerns on violence of women and children, mainly sexual, domestic, and intimate partner, but also sextortion, online harassment, and economic justice for women, which restrict them to enjoy their fundamental freedom. It is the fact that inadequate budget allocation to implement the National Plan of Action on Women and Children limits enough promotion to protection of women and children's rights. Lastly, protection of human rights in the business sector. The issue of human rights and the business face challenges with a lack of national human rights and a business action plan, but also we have loopholes in laws such as Employment and Labor Relations, Workers' Compensations Act in regard to the rights of workers and the benefits, workers on benefits and the fair compensation when the situation of accident and injuries occurs at the workplace. Lastly, we observed poor participation of community members in the process of acquisition of land for investment, attributed by lack of villagers' awareness, which needs government intervention to protect village land over the unbenefited investment to the community. Honorable Chairperson, LHRC, we call the Commission to urge the government to do the following. Number one, to amend all laws that infringe on fundamental rights, on freedom of association, freedom of assembly, in order to make them to align with the regional and international instruments. But also, the government of Tanzania to prioritize the issue of women and children, particularly gender-sensitive budgeting and access to justice. We also urge the government of Tanzania, we call the Commission to urge the government of Tanzania to finalize the development of the National Action Plan on Business and the Human Rights. But also, we call the Commission to urge the government to respect and execute international and the regional court decision and the instruments, and also to finalize the development of the National Human Rights Plan of Action. Lastly, we call for the Commission to visit the United Republic of Tanzania for reviewing and advising the government on the current situation on human rights in compliance with the African Charter on Human and People's Rights. Thank you.
Thank you for your statement and also for doing so almost within the time limit. It was a statement that focused mainly on the state of human rights in Tanzania, highlighting concerns relating to certain laws having restrictive impact on the enjoyment of particularly political freedoms and freedoms relating to freedom of expression and access to information, and those relating to access to justice as well. The point that you have made, of course, in respect of socioeconomic rights, which the Commission join you in welcoming, relate to those of universal access to education, which have facilitated increased enrollment of children into the education system, which is a very positive development. And indeed, it can be enhanced with the necessary financial and resource investment to enhance its effectiveness. And of course, the concern as far as the prevention of access to education of pregnant girls is a continuing concern for the African Commission. This is contrary to Article 2 of the African Charter, which prohibits discrimination. It is also contrary to the Maputo Protocol. There is no reason why girls, on account of their status, are precluded from having access to education, while potentially their boy peers who might have been implicated in these situations are allowed to continue to have access. In any case, I think it is something that we hope the government of Tanzania would review in order to ensure that these girls, added to their situation of being pregnant, wouldn't be put in a more difficult situation of being disadvantaged because of being prohibited from access to education, which is critical for their future and socioeconomic well-being. Issues relating to, of course, women and children that you have highlighted, again, are being reiterated. Just like other countries, it is an area of concern. We also take note of the various proposals that you have put forward relating to human rights and business, and also the finalization of the National Human Rights Action Plan, among others. So we thank you for your statement. And we, personally, myself, as the country rapporteur of Tanzania, invite you to continue to engage with us as the African Commission, so that together we are able to address the various issues. And indeed, we would reach out and contact Tanzania in order to, for us at the African Commission, to be granted the possibility of undertaking a promotion mission. Thank you, Legal and Human Rights Center, for that. The next is Ogiek Peoples. Ogiek Peoples. Do we have Daniel Kobe? This is the NGO with observer status number. Before that, colleagues, I see here that we have actually confirmation that the chairperson of the DRC National Human Rights Commission is with us. If we indeed do have that, we can first give the floor to the chairperson of the DRC National Commission of Human Rights. I see the name is Honorable Mwamba Mushikonke Mwamus. If you could check that. Okay, we don't have. How about the president of the National Human Rights Commission of the Sahrawi Arab Democratic Republic? I think we have Mr. Abbas Salek. I get an indication that Mr. Abbas Salek is with us. This is the National Human Rights Commission of the Sahrawi Arab Democratic Republic, I understand, which has been registered with affiliate status number 27. Mr. Salek, you have the floor, please. Welcome. Thank you very much.
Bonjour, vous m'entendez?
Oui.
Bonjour à tous. Excellence, Monsieur le Président de la Commission, honorable commissaire, membre de la commission, Excellences, mesdames,
excuse me. Etwell, can you please deal with this voice that is interfering? I don't know where it's coming from. Okay, please proceed. There is still this voice, Etwell. I don't know where it's coming from.
Monsieur le Président, depuis la dernière session, notre commission des droits de l'homme a pris l'initiative d'organiser plusieurs activités liées à sa mission dans le domaine de promotion des droits de l'homme malgré les circonstances liées à la pandémie de Corona. Dans ce contexte, notre commission a célébré la Journée africaine des droits de l'homme avec la participation des représentants de la société civile sahraoui. Cette journée a été consacrée à la situation des détenus politiques sahraouis dans les prisons marocaines, compte tenu du risque qui menace leur vie en raison du déclenchement de la pandémie dans les prisons marocaines et la passivité des autorités marocaines à répondre à l'appel du Haut Commissariat des droits de l'homme aux États et gouvernements pour libérer les prisonniers politiques. Notre commission aussi a participé à plusieurs conférences webinaires liées à plusieurs sujets comme la décolonisation du Sahara occidental, la situation des prisonniers politiques sahraouis aux prisons marocaines, l'exploitation illégale des ressources naturelles du Sahara occidental, méthodes et techniques pour l'élaboration des rapports alternatifs et aussi le sujet de la santé et les droits de l'homme. Au cours du mois de juin 2020, notre commission a signé aussi un accord important avec l'organisation internationale ACHPR concernant la promotion des droits de l'enfant en coopération avec le ministère de l'Éducation, et ça dans le cadre des projets d'amélioration de l'accès à une éducation de qualité dans les camps de réfugiés sahraouis financés par l'organisation UNICEF. Monsieur le Président, notre commission souhaite rappeler les dispositions pertinentes de la Charte africaine des droits de l'homme et du peuple, en particulier les articles 20 et 21. Et nous tenons également à rappeler que le Maroc, jusqu'au jour, est le seul pays qui n'a pas ratifié la Charte africaine des droits de l'homme et du peuple et qui n'a pas permis à votre estimée commission de visiter les territoires occupés de la République sahraoui en application de plusieurs décisions prises par le sommet de l'Union africaine. Et ça se soulève plusieurs questions sur cette intransigeance et comportement irresponsable. Monsieur le Président, Mesdames, Messieurs, les récents développements au Sahara occidental, après la violation flagrante de cessez-le-feu par les troupes militaires marocaines le 13 novembre 2020, en raison de l'intransigeance du Maroc et de son action illégale dans l'exploitation d'une brèche illégale dans la région de l'Gargaret, au sud du Sahara occidental, après que les forces marocaines ont pris d'assaut la zone tampon en violation de l'accord de cessez-le-feu entre les deux parties sous la supervision des Nations Unies en 1991. Cette intransigeance a conduit les citoyens sahraouis de la société civile à fermer la brèche illégale et à organiser des manifestations pacifiques pour protester contre la négativité du rôle des Nations Unies et son échec à mener à bien l'organisation d'un référendum d'autodétermination du peuple sahraoui. Monsieur le Président, notre commission est aujourd'hui très préoccupée par les événements enregistrés dans les villes occupées du Sahara occidental où les autorités marocaines ont bouclé le siège des maisons des militants sahraouis et les défenseurs des droits de l'homme et une campagne d'arrestation, la répression des manifestations pacifiques, prise d'assaut des maisons dans une atmosphère de terreur et de déploiement massif des forces de sécurité marocaines dans les quartiers des Sahraouis. Nous appelons d'urgence la Commission africaine des droits de l'homme et du peuple à jouer un rôle décisif et positif dans le suivi de la situation de guerre aujourd'hui au Sahara occidental et suit aussi la situation préoccupante des droits de l'homme et des peuples et à visiter les territoires occupés de la race pour découvrir la réalité et la vérité à la lumière de la situation dangereuse aujourd'hui dans la partie occupée avant qu'il ne soit pas trop tard et doit agir d'urgence pour accélérer la mise en œuvre du mandat que vous est confié conformément aux décisions du Conseil exécutif de l'Union africaine. Je vous remercie, Monsieur le Président.
And thank you very much for that statement of the National Human Rights Commission of the Sahrawi Arab Democratic Republic, and also for providing us updates on the various activities undertaken by the Commission, including the event that was held on Africa Human Rights Day with the participation of various stakeholders and the various engagements of the National Human Rights Commission relating to various issues highlighted in seminars and workshops indicated earlier on. The issue of Western Sahara as it relates to, in particular, recent developments, including the difficult situation relating to the ceasefire in Western Sahara, and indeed the danger that this entails for the peace process, for the security of the region. And indeed, the Commission, within the framework of Article 23 of the African Charter, which proclaims the right to peace and security, calls on Morocco and the Sahrawi to return back to and abide by the ceasefire, which is critical for the search for lasting solution in the Sahrawi Arab Democratic Republic. And indeed, this has to be done within the framework of the right to self-determination under Article 22 and Article 20 of the African Charter, and indeed with due respect to all the rights enshrined in the African Charter. We at the African Commission, through the country rapporteur, continue to monitor the situation and within the parameters of our jurisdiction, continue to engage, but there is a limit to our jurisdiction, as you rightly pointed out, on account of the fact that we do not have direct legal relationship as a state party with Morocco. However, within the framework of the decision of the African Union, whatever collaboration and coordination we can be able to have, we would indeed welcome that. I'm not sure if we have any other national human rights institution. If we don't have that, we'll go back to the next one, that is from the list of NGOs with observer status. Earlier on, I called the OGEC people. Do we have? I see Etwell. I see a hand from your side.
I think we now have Malawi. Sorry, from RDC, I think.
We have the chairperson of the National Human Rights Commission of DRC.
Yes, I think Mwamba Mushin Konke. We now have.
Okay, great. Please. Okay, it looks like that we have a very serious difficulty in establishing connection with the chairperson of the National Human Rights Commission of the DRC. Can I then request if we can have OGEC Peoples Observer Status 426, Mr. Daniel Kobe. Thank you. I think that will be all right. It looks like that we have the chairperson of the National Human Rights Commission of the DRC. Okay, Honorable Moamus, can you please put on the mic and take the floor?
Okay, j'espère vous m'entendez.
You are very welcome. Very welcome.
Ça va?
You have 7 minutes, please. Thank you.
Ok, merci. Ok, merci. Honorable Président de la Commission africaine des droits de l'homme et des peuples, honorable commissaire, Monsieur Gilbert de RINAD, Mesdames et Messieurs les participants, la Commission nationale des droits de l'homme a fait une déclaration sur la situation des droits de l'homme en République démocratique du Congo. La CNDH-RDC remercie d'abord la Commission africaine des droits de l'homme et du peuple pour sa participation. Sans plus tarder et pour bien être dans les minutes, d'emblée, je vais vous dire que nous avons observé par rapport à la situation
That is unfortunate. We have lost the chairperson of the National Commission of Human Rights of the DRC. I see my colleague Ethwell shaking his head. Yeah, it looks like that we are disconnected. Okay, we are back again. Okay, can you put on your mic, please? Your mic is not on. Your mic is not on.
ça va
Okay,
maintenant?
please proceed.
Ok, ça va. Alors, nous avons remarqué des avancées dans les chefs du gouvernement en rapport avec la situation des détenus politiques, des libérations de l'espace démocratique et aussi en rapport avec les manifestations publiques. Nous avons remarqué aussi des avancées dans les droits économiques, socioculturels, surtout avec la mise en œuvre de la gratuité, de l'enseignement des bases. Et nous avons aussi remarqué des avancées en rapport avec la présence, la représentativité des femmes dans les gouvernements. Mais malgré ces avancées, nous avons constaté que la situation des droits de l'homme ne s'est pas améliorée. s'est pas amélioré, surtout en ce qui concerne les droits civils et politiques, les tracasseries policières, les détentions arbitraires pour des faits civils et faits bénins. Nous avons remarqué beaucoup de situations en rapport avec la détention préventive. Nous avons trouvé qu'il y a surpopulation carcérale, dont certains détenus sans dossier dans des prisons, d'autres qui sont déjà acquittés, mais qui traînent encore en prison, et beaucoup de dépassements des délais dans le traitement des dossiers. Donc, il y a beaucoup de matières que nous avons remarquées qui concernent beaucoup de cas de violation des droits de l'homme. Alors, nous avons aussi observé dans les droits économiques, socioculturels, que malgré la gratuité prônée qu'on a mis en œuvre pour absorber les 4 millions d'enfants qui ne partaient pas aux écoles, mais il y a un problème de paiement de nouvelles unités. Les paiements des enseignants qui ont totalisé des arriérés de plus de 10 ans, 15 ans, 5 ans sans être payés. Donc, malgré la gratuité, il y a un problème des enseignants qu'il faut payer. Et il y a les problèmes de surpopulation dans des classes. Les normes est qu'il faut 30 à 35 élèves dans une classe, mais en RDC, la loi autorise même jusqu'à 50. Mais avec l'effet de la gratuité, nous sommes dans les 150. Donc, les conditions de l'enseignement posent problème avec le phénomène de la gratuité parce qu'on n'a pas construit les nouveaux bâtiments, donc de nouvelles salles pour absorber la gratuité. Maintenant, en matière, nous déplorons aussi en matière de droits collectifs. Vous trouverez qu'en RDC, les conflits armés posent un sérieux problème de violation des droits de l'homme. Nous avons des groupes armés nationaux qui opèrent à l'est de la République. Nous avons aussi les groupes armés étrangers qui opèrent en RDC, ce qui fait que la population de l'Est jusqu'à aujourd'hui vit dans un contexte de déplacement permanent à cause des conflits armés. Mais il y a aussi des conflits intercommunautaires. Là aussi, ça pose des problèmes. Donc, la population enregistre beaucoup de déplacés internes, sans oublier, bien sûr, les réfugiés, ceux qui ont la chance de traverser dans d'autres pays. Mais il y a des déplacés internes à cause des conflits communautaires et des conflits orchestrés par les groupes armés. Et sur le plan des droits catégoriels, nous avons pris l'exemple des droits de la femme. La représentativité de la femme dans les instances de décision est faible. Jusqu'à aujourd'hui, on n'a jamais atteint 30, ne fût-ce que 30%. Alors que la Constitution nous recommande d'avoir la parité dans les espaces de décision. Nous avons fait les enquêtes au niveau de province. Nous avons rencontré que sur 10 ministres exigés pour chaque province, vous trouverez des fois 0 femme sur 10 ou une femme sur 10, rarement 2 femmes sur 10. Alors que dans nos provinces, il y a des femmes capables et compétentes d'être ministres, mais ce n'est pas possible. Même pour le gouvernement national, bien sûr, on a nommé des femmes, mais on n'a pas atteint même 20%. Donc, c'est pour vous dire que sur tout le plan, la CNDH déplore la situation des droits de l'homme. Donc, le respect des droits de l'homme, c'est un problème. Donc, la situation, pour conclure, la situation des droits de l'homme reste préoccupante et qu'il faut un effort surtout par rapport à la paix en RDC, à l'est du pays. Là, il y a un sérieux problème. Il y a circulation des armes légères et petits calibres. Il faut le concours de tout le monde pour que la RDC soit en paix. Comme vous le savez, là où la paix est troublée, les violations des droits de l'homme s'en suivent. C'est pour cette raison que nous avons voulu demander à la Commission africaine des droits de l'homme et des peuples pour qu'il puisse accompagner la CNDH-RDC afin que la situation des droits de l'homme en République démocratique du Congo puisse s'améliorer. Je vous remercie.
Thank you very much for that statement of the National Human Rights Commission of the DRC, providing us an update on the state of human rights in the DRC, covering a wide range of issues, providing us with some of the positive developments, including opening of the political space, and also the provision of free schooling, free basic education, some marginal improvement in representation of women, if the translation was correct. But as the chairperson highlighted, quite a lot of issues that need to be addressed as far as human rights are concerned in the DRC, ranging from police brutality to issues relating to the effective implementation of free schooling in the DRC, particularly non-payment of salaries of teachers, overcrowding of schools, lack of building of new classrooms and schools, which affects access, quality access to education. The question of peace and security, particularly affecting the eastern part of the DRC, has been highlighted, and we agree with you, Chairperson, that indeed wherever there is no peace, human rights are in danger, and therefore it is a cause for serious concern that the state of the Eastern DRC, as you put it, is in a permanent state of flux and displacement, resulting from the operation of various armed groups and indeed from that of intercommunal violence. We join you in calling for enhanced security in the Eastern DRC through the provision of security services, through the enhancement of the national infrastructure for law and order, and indeed through improved intercommunal relationship in Eastern DRC. We also join you in deploring the fact that there are almost no women representation in the 10 ministries of the provinces, and indeed we call on the government of the DRC to see to it that this state of affairs in the representation of women is improved, and that actions are taken and national plans are indeed put in place in order to achieve the 30% representation at the national level. Thank you once again for your statement, and the Commission wishes to assure you that it would be at your disposal to provide support for your work and to join hands with you towards addressing these various issues of human rights in the DRC. Thank you once again. Let me give the floor to, because we already have called him and he has been waiting for us with patience, the representative of the Ogiek peoples. This is the NGO with observer status number 426. You do have the floor, please. You have 5 minutes, and thank you for bearing with us.
Thank you, Chairman. Honorable Chairman, Honorable Commissioner, State Delegates, ladies and gentlemen. My name is John, and I'll be reading the statement on behalf of the Ogiek people of Kenya. Chairman, the Ogiek community are indigenous people of Kenya with a current population of 52,000, according to 2019 census. The Ogiek community and the Commission have been intertwined in their case forwarded by the Commission to the African Court in 2012. We have worked together in the long journey, which brought the landmark judgment of the 26th May 2017 in favor of the Ogiek community. I say kudos to the Commission for standing with us until now. Chairman, despite a strong African Commission judgment which offered the Ogiek community hope, their situation has rapidly deteriorated in recent months. Firstly, there has been a continued delay in implementing the Ogiek judgment. It is now 3 years since the Ogiek case was won, but the government has taken no steps to remedy the plight of the Ogiek community, and indeed has taken steps which wholly conflict with the judgment. Instead, they have enjoyed a game. Of forming task forces whose reports have never been made public and who never seem to have taken any concrete action in the Ogiek's favor. Most recently, they formed a multi-agency team for Eastern Mau, which ignores the Ogiek living in other parts of Mau complex. This, in return, has had a lot of negative impact, since the Ogiek community were not consulted about this formation or its action, in violation of the Ogiek rights to free, prior, and informed consent. More concerningly, during July and August this year, over 1,000 members of the Ogiek community were evicted without notice by the Kenya Forest Rangers, with the support of the Rift Valley Regional Commissioner. This led to over 500 Ogiek being rendered homeless, despite the government having declared a moratorium on eviction during the COVID-19 pandemic. The old and the young suffered more, as movement for them was constrained due to the pandemic. Some Ogiek crowded in school and others moved to live in neighborhoods. None of these Ogiek received humanitarian support from the government, in contravention of COVID-19 protocol. The Kenya government official claimed that this eviction were a necessary precursor to implementation of the 2017 judgment, when they in fact directly contravened it. This eviction stoked underlying ethnic tensions with non-Ogiek community illegally settled in the Mau Forest complex, who blame the Ogiek for recent eviction and fear that the implementation of the 2017 judgment will result in their removal. This has resulted in the eruption of ethnic clashes, leading to several deaths, others being injured and hospitalized, many falsely arrested, and more than 100 homes being torched and burned down. Despite the clashes, 3 Ogiek youths were shot dead by police, but there has been no independent investigation. In an attempt to subdue the violence in early August, local authorities brokered peace between Ogiek and non-Ogiek representatives. The announcement that a team of surveyors would demarcate clear boundaries between the land earmarked for settlement in the 1990s and the forest and the Mau Forest. Officials noted that the government of Kenya would address implementation of the court's 2017 judgment once the demarcation exercise has been completed. The multi-agency team has now proposed a land titling process and audit that would see both Ogiek and non-Ogiek given 5-acre plots of land as private parcels in the Eastern Mau. This proposal completely ignores that the underlying fact that the underlying land is Ogiek ancestral land subject to the reparation process before the African court, and that the Ogiek are seeking a collective title to their ancestral land as part of their reparation process to safeguard their culture as an indigenous people. It also failed to address the situation of members of the Ogiek community who do not reside in the Eastern Mau. This has happened without involving the Ogiek community and in total disregards of the court's judgment, and by bringing in other communities to take up Ogiek land in the name of inclusivity. In addition, other human rights defenders have been threatened since Ogiek won their case, climaxing when the government formed a task force to look into the implementation of the OGEC. The threats have continued. Finally, the government has continuously postponed the African Court's reparation hearing scheduled for March 2020 and then reset for September 2020, relying mostly on the COVID-19 pandemic. It will now be scheduled until next year. In the meantime, the government is evicting the OGEC and contravening the judgment. Continued delay is creating continued uncertainty and suffering for the OGEC community. Chairperson, in conclusion, the OGEC implore Honorable Commission to liaise with the African Court and request that it fast-track the reparation hearing. Chairperson, the OGEC also asked that the African Commission use its good office and mechanism to urge the government of Kenya, 1, implement the judgment in full consultation with the OGEC leadership structure in place, including the OGEC Council of Elders and the OGEC People's Development Program. Provide protection and assurance of the same to human rights defenders, their families, and their properties. 3, respect the wishes of OGEC Council of Elders as far as settlement is concerned, granting them community land, not 5 acres of land per family. Finally, we request the Commission visit the community and hear from them the way things are on the ground and endeavor to update on time. Thank you so much for the time. Thank you.
Thank you very much, OGEC people, for that statement relating to the state of human rights as it concerns the OGEC people, particularly the challenge of implementation of the 2017 judgment of the African Court on Human and People's Rights on the land rights of the OGEC in the Mau forest, including recent developments affecting the OGEC, particularly incidents of evictions, as well as the initiation of demarcation and land titling, which is being implemented under conditions where that may actually undermine the court judgment. And also we take note of your request for the government to implement measures in full consultation with the OGEC people, particularly the OGEC Council of Elders, and of course the need for taking inclusive measures for the implementation of the 2017 court judgment, as well as the fast tracking of the reparations hearing by the African Court on Human and People's Rights, all of which we duly take note of, and as we have been doing, we will continue to follow on these items. Should time permit and allow us, and we get authorization, of course, we would be happy to undertake a promotion mission to Kenya as well. Thank you for that. I don't think that we have any more time to continue for today's session. I think this brings us to the end of today's session. Colleagues, honorable members of the Commission, staff of the Secretariat, distinguished delegates of state representatives, NHRIs and CSOs, as well as the interpreters, I wish to express my appreciation to each and every one of you for your kind patience, as we have been struggling early in the morning when we started to maintain a stable connection and a smooth conduct of our proceeding. I think we did all the best that we can. We will try to improve this as we move forward in the next days as well. This brings us to the end of today's session. I wish you all a very good afternoon and a good evening. We will come back again tomorrow at 9 GMT for the 5th day of our 67th ordinary session. May I take the opportunity to kindly request colleagues, members of the Commission, to stay behind, please, for a brief meeting. Thank you very much.